Utilities Commission. With me this morning are Chairman William M. Brawley and Commissioners Tommy Tucker and Donald Vandervaart. I now call for hearing docket number E2 sub 1358 in the matter of application of Duke Energy Progress LLC relating to fuel and fuel-related charge adjustments for electric utilities pursuant to North Carolina General Statute Section 62-133.2 and Commission Rule R8-55. Before we proceed further, and as is required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has any known conflict of interest with respect to this docket. Okay. Let the record reflect that no such conflicts were identified. On June 10, 2025, Duke Energy Progress LLC, that I'll refer to going forward as DEP, filed the direct testimony and exhibits of DEP witnesses Kevin Houston, Nicole Flippin, Jeffrey Flanagan, John Schwez, Dana Harrington, and Kelly McNeil. The Carolina Utility Customers Association, Inc., the Carolina Industrial Group for Fair Utility Rates 2, which I will refer to as SIG for 2, the North Carolina Sustainable Energy Association, that I will refer to as NCSEA, and the Southern Alliance for Clean Energy, that I'll refer to as SACE, and the Sierra Club have petitioned to and been allowed to intervene in this proceeding. The public staff, which represents the using and consuming public, has been made a party to this proceeding in accordance with North Carolina General Statute Section 62-15D. On July 15, 2025, the Commission issued an order scheduling hearing, establishing procedural and filing requirements, and requiring public notice. On July 18, 2025, DEP and the public staff filed a joint proposed public notice of hearing for this docket. On July 21, 2025, the Commission issued an order approving the public notice. On August 18, 2025, DEP filed a motion for leave to file the direct testimony and exhibits, which contain confidential provisions of DEP witness Flippin, adopting the testimony and exhibits of DEP witness Tom Simrel, and the filing of direct testimony and exhibits, which contain confidential provisions of DEP witness Houston, adopting the direct testimony and exhibits of DEP witness Matthew Cameron. On August 27, 2025, the Commission issued an order granting this motion. On August 19, 2025, DEP filed the supplemental testimony and revised exhibits of its witnesses. On August 25, 2025, the public staff filed a motion for leave to file pre-hearing briefs and a request for oral arguments that I will refer to as the public staff motion for oral arguments. On September 2, 2025, the public staff filed the direct testimony and exhibits of public staff witnesses Hemoth Mehta, Vivian Fang, and Evan Lawrence that contained confidential provisions. Also, on September 2, 2025, SACE filed the direct testimony and exhibits of SACE witness Michael Goggin, and NCSEA filed the direct testimony and exhibits of NCSEA witness Albert Lynn. On September 3, 2025, DEP filed its response to the public staff's motion for oral arguments. On September 5, 2025, DEP and the public staff filed a joint proposed public notice. On September 11, 2025, the Commission issued an order granting the motion for leave to file pre-hearing briefs and scheduling oral argument. On September 16, 2025, DEP filed the rebuttal testimony, which contains confidential provisions of DEP witnesses Schwez, Flanagan, Cedric Lloyd, Harrington, and Brian Sykes. On September 17, 2025, DEP and the public staff filed their pre-hearing briefs. On September 19, 2025, the Commission issued an order approving the public notice. On September 22, 2025, the Commission issued an order clarifying and providing procedures for oral arguments. That brings us to today. I now call upon counsel for the parties to introduce themselves for purposes of the record, beginning with the applicant.
Good morning, Presiding Commissioner LaDon Tune, appearing on behalf of the company. Good morning, Chair Raleigh and members of the commission as well. Also appearing on behalf of the company is Mr. Jack Drack, as well as Brett Bryshort with the Office of McGuire Woods.
Okay. Good morning.
Good morning, Presiding Commissioner Kimmerite. Peter Ledford of the law firm Morton Smith, appearing on behalf of the Carolina Industrial Group for Fair Utility Rates 2 and the Carolina Utility Customers Association.
Okay. Good morning.
Good morning, Presiding Commissioner Kimmerite, Menashe Nagara, appearing on behalf of Southern Alliance for Clean Energy and Sierra Club, which I'll refer to collectively as SACL.
Okay. Good morning.
Good morning, Presiding Commissioner Kimmerite. Justin Smolowski on behalf of the North Carolina Sustainable Energy Association, NCSCA.
Okay. Good morning.
Good morning. I'm Will Freeman, and with me is Zeke Creech. We're here with the public staff on behalf of the using and consuming public.
Okay. Good morning. Are there any preliminary matters that need to be addressed at this time?
None from the applicant.
Okay. Seeing that there are no preliminary matters that need to be addressed, we will proceed with the oral argument portion of the hearing. And then again, before we get started with the oral argument, are there any preliminary matters that need to be addressed regarding the oral arguments?
None from.
So seeing none, we'll move forward. Pursuant to the order clarifying and providing procedures for oral arguments, only the parties who submitted pre-hearing briefs on the matter are permitted to present their oral arguments. Therefore, the public staff will present its oral argument first, followed by DEP. Each party's oral argument is limited to 25 minutes, and each party will be notified when there are 5 minutes left in the 25-minute time period. Commissioners will be able to ask questions of each party immediately following each presentation, and the commission questions will not count toward each party's allotted time. So with that, we're ready to proceed with the oral argument. Counsel for the public staff, please approach and you may proceed with your oral argument.
Thank you. Morning, Commissioners. As I said a minute ago, my name is Will Freeman, and with me is Zeke Creech. We're here with the public staff on behalf of the using and consuming public. Thank you for your attention, and we appreciate this opportunity to talk on this topic with you.
Yes. Yeah, thank you.
Is that better? And we're here about the fuel rider, which yesterday I learned is the grandfather of all riders. So Granddad Will is here. Specifically, we're here about the part of the law that allows Duke to recover its actual and historic costs of fuel and fuel-related costs that Duke has already incurred. And of those incurred costs, we're only here about 3 months, April, May, and June of 2025. I'm going to call that the update period. That's what we've referred to it in our various briefing. And as you know, Senate Bill 266 made significant changes to the law governing the fuel rider, the proceeding we're here about today. And the General Assembly made a very deliberate choice for that new law to be effective July 29th, 2025. The effective date is literally written into the law at Section 7, which states, this act is effective when it becomes law. And then if you read a little further on in the bill, again, Senate Bill 266 by its own language says it became law, notwithstanding the objections of the governor at 10:21 a.m. this 29th day of July, 2025. And July 29th is an important date. It's a line. It's a line, and there's big differences if you're on a different side of that line. So a rail car full of coal or a pellet of uranium or a capacity element of a power purchase, whatever fuel cost you want to talk about, all the fuel costs incurred before July 29th fall under the old law. And all the coal and natural gas and fuel costs after July 29th fall under the new law. And what Duke is trying to do in this proceeding is pull these old historical costs into the area of the new law. They're trying to retroactively apply the new law to those old costs. And that's just not allowed. It's pretty clear. It's not allowed for 3 reasons. First and foremost, the General Assembly said so. They said, hey, July 29th, that's when it's effective. Second, the fuel rider statute says Duke can only recover its incurred, past tense, incurred costs. And third, new laws are not retroactively applied unless it's crystal clear. In fact, the North Carolina Supreme Court said every reasonable doubt is to be resolved against a retroactive operation of a statute. So I think it's pretty clear cut. Fuel costs incurred before the law changed, governed by the old law. Fuel costs incurred after the law changed, governed by the new law. That's pretty much the public staff's brief, but I would like to take a minute to respectfully tell you why I think Duke's arguments are unpersuasive. One of Duke's arguments is, hey, it just makes sense that the update period should be audited under the same recovery framework as this new law. And that's on page 2 of their brief. And response to that, I'd say just because something's easier doesn't mean it's lawful. The argument kind of distracts from the clear language of the statute, which discusses how you recover incurred costs, not how you do what's easiest. Another argument that Duke makes, and they spend a fair amount of ink on this one, is in 2007, there was a law, Senate Bill 3, a session law passed in 2007, made a lot of changes to this field. And the General Assembly passed that legislation and said in this old Senate Bill 3, hey, you shouldn't apply this bill to fuel costs incurred before January 1, 2008. And Duke says, hey, this shows that the General Assembly knows how to give instructions to the commission, right? They did it there. They told you how to apply it and when to apply it. And so because the General Assembly didn't do that in today's bill, then it's okay to apply Senate Bill 266 retroactively. And Duke says there's nothing in the new law to suggest the General Assembly intended to prevent retroactive application. And so I have a few points I'd like to make there. It's not the best example for Duke because in Senate Bill 3, the old law, the legislature said, hey, this part applies retroactively, this part applies prospectively, and this part applies when effective. Like they went through. So I can kind of turn Duke's own argument against it because in general, the General Assembly in 2007 said, hey, Section 9 should be applied retroactively. And because the General Assembly didn't do that here, and we know they know how to do it, then we can't apply it retroactively, right? It's the same argument. They know how to do it. I would submit respectfully, the General Assembly knows that laws aren't retroactive unless they say so. The Supreme Court said that for at least 100 years, North Carolina Supreme Court. So, and that is, it kind of turns the law on its head, right? What I think of as like the default setting was what the Supreme Court said. Every reasonable doubt is resolved against retroactive operation of a statute. And third, and again, not least, the General Assembly spoke on this topic. It picked July 29th as the effective date. Another argument kind of related to that one that Duke makes in its brief is in the 2000, there was a proceeding in the commission in 2009 where the commission was wrestling with Senate Bill 3 because it made a lot of changes. And in that one, the commission, one of the things Senate Bill 3 said is, hey, look over the whole state, see how much energy we need, see how much capacity we need. And if there's a problem with a CPCN, revoke it. And so in that case, the commission was kind of retroactively applying the law in the sense that it was looking at already issued CPCNs to see if they could be revoked. And Duke's like, well, see, you can apply laws retroactively. But as the commission said in 2009, the law that the Senate Bill 3, that part of the law by its very nature relates to review of a previously issued certificate. So when I said you can't go back retroactively unless it's crystal clear, that's an example of when it is crystal clear. When the General Assembly says, go back and look at all the CPCNs and see which ones need to be tweaked, that's a retroactive application. Or when they specifically spell it out near the end of the law, that's when you can retroactively apply. We don't have either of those circumstances here. Another sort of general category of arguments that Duke makes is there isn't a retroactive problem because rates are going to be set by the commission in an order that will come out after July 29th. And also, all the rates are prospective, right? They're all going to start after July 29th. So as Duke put it, the mere fact that the company's prospective application implicates facts occurring prior to enactment of the law does not render the application impermissible. And I disagree. And I think, well, first, that's not what the Supreme Court told us to do, resolve every doubt against retroactive application. But also, if we look at some cases, I think that helps us understand what happens. And I cited a couple in my brief. One is the Estridge case. What happened there is we had a car leased in September of 1987. In October of 1987, a law, the Lemon Law, was passed. And in October of 1989, the plaintiff, she sued the dealership, said, I got all these Lemon Law problems with my car. And she's like, hey, all my problems arose after the law. The court's like, no, 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 the start event, the trigger event's back here when you bought it before the law came around. You cannot use the law. So those arguments were rejected by the court because they kind of look to the start date. They look to when the kernel began, right? And the Wilson Ford tractor case was the same thing. It was a local dealership. March of 1983, the plaintiff buys a franchise. New law passed October 1st, 1985. A couple of weeks later, the plaintiff sues and says, this bad contract exists today, and I want to sue under the new law. And the court said, no, no, no. You go back to here in 1983, when you signed that contract. Yeah, it exists today, but it all kind of started before the law, so you cannot retroactively apply it. And the third case is one cited by Duke. It's the Bollock case. And in that case, the plaintiff was injured by a machine June 3rd, 1977. New law, October 1st, 1979. A couple weeks later, plaintiff sues that machine manufacturer, said, your machine hurt me. They said, no, no, this new law says you can't sue us. And the court's like, no, no, no. It all started before the new law. In that case, the defense is trying to retroactively pull it forward. And they're like, nope, it all stays. There's a line when the law is passed and your event, your injury happened before. And the Bollock case, which is cited by Duke, the language of the court, when it talks about this kind of starting period of time, it said the proper question is whether the new law, quote, as applied, will interfere with rights which had vested or liabilities which had accrued at the time it took effect. And the court's just telling us, hey, got the new law, and what happened on this side of the law? Was it a big deal or not? If it's a big deal, that's when it starts. If it's not a big deal, it starts afterwards. Flowing from this kind of Bollock argument that Duke makes, Duke then says, hey, there's no vested right implicated by the company's approach because the proposed fuel rider at issue is still pending review and has not been fixed for prospective operation by the commission. And Duke then goes on to say there's no property rights implicated by the commission's application. So Duke's argument is, hey, these fuel costs are not vested. They aren't property rights. They're just too indeterminate and vague at this point until you issue an order that says they can be recovered. They're so vague that they didn't really start before the law. They kind of started after it. And if these costs are that insubstantial, then Duke shouldn't be allowed to recover them. The law, new and old, only allows recovery of costs actually incurred in this fuel rider. And I guarantee you, if we disallowed the $400 million of costs in those 3 months, because they were not yet vested or property or substantial, we'd hear the howls from headquarters in Charlotte all the way here in this room. These are real costs. They have been incurred. They're literally on the books. They've already been incurred. And because they were incurred before the new law was enacted, they stuck with the old law. They're governed by the old law. And Duke cannot now bring them forward and apply the new law to them retroactively. It just, at the end of the day, it just kind of seems like a clear-cut line. Legislature made a line, costs before July 29th, old law, costs after July 29th, new law. I appreciate the commission's time, and I'd be glad to try to answer any questions.
Thank you for your oral argument. I'll begin with some questions, and then my fellow commissioners may also have some questions. To start with, you talked about Duke's general argument that you view is that Duke is trying to retroactively apply Senate Bill 266, which was enacted July 29th of 2025. But wouldn't you agree that Duke's primary argument is that they are not retroactively applying 266, that they believe that because rates have not yet been set, it is a prospective application? That is the essence of their primary argument. Is that your understanding?
I felt like there was a big chunk of their brief kind of addressed to that concept of what you're getting at.
Mm-hmm. And what we're talking about in this proceeding are costs for the 3-month period that you talked about, April, May, and June of 2025. But what I want to focus on is I want to make sure that the commission that we're doing statutory interpretation, and that we want to make sure that we correctly apply and legally, from a legal perspective, 266 to this application, but we're here for the 2025 fuel cost proceeding. And so we're talking about those 3 months in April, May, June 2025. But doesn't 266 also potentially implicate the 2026 fuel cost proceeding?
I agree. And I think we'll be asking in 365 days when we're here again for all the fuel costs from July 1st to July 28th to fall under the new old law too. And maybe we'll get some timestamps of when that fuel came in and be like, oh, the ones at 1020 old law, the ones at 1022 new law.
And I'll get to the 2026 proceeding in a minute, but because I do have some questions about that. But so from my review of 266 and the parties' arguments, we're trying to determine what triggers the application of Senate Bill 266. And from my analysis, it seems like there's 3 possibilities, and we have to determine which is correct. One has not been argued by the parties, I don't believe. The first one would be, I think, the public staff's position, the date that the fuel costs were incurred, which would mean in the 2026 proceeding, there would be some purchases in 2025 that would be before application of 266. That would be the first scenario. The second possibility that I don't think, and please correct me if I'm wrong, that any party has argued is that what triggers the application of 266 would be the date that the fuel rider application is filed, which would mean that all costs that are being considered in that application would fall under 266. But I don't think that that's something that any party has argued in this proceeding. And please correct me if I'm wrong.
I expect that you're correct. I don't want to speak too much for Duke, but it's from the public staff's point of view, absolutely.
Yeah. And then the third possibility would be the date that the commission issues an order for new rates based upon incurred costs. And if that is the scenario, it seems to me that Duke could make the argument that all costs that were incurred for the 2025 proceeding would trigger application of 266, but that's not Duke's argument here, is my understanding, because we're only arguing about the 3 months of April, May, and June of 2025. Is that your understanding as well?
I would say that's my understanding. Again, my impression of Duke's argument is the new law be in effect for the next fuel rider, and so that's when, therefore, therefore, the update period and the next fuel rider will all be governed under Senate Bill 266, is how I read Duke's argument.
Okay. And so I think it's important to think about the 2026 fuel proceeding. And correct me if I'm wrong, but I believe that I read that Duke and the public staff have reached an agreement, and that for the 2026 proceeding, that all costs for that proceeding will be subject to Senate Bill 266. Is that correct? Is that the agreement that was reached?
Respectfully, I don't think that was, and I apologize if you gave that impression. the agreement that, one of the things Senate Bill 266 did is shift some things from the base case into the fuel rider. And there was large alignment on the sort of methodology for doing that. And the Duke suggested one method, we suggested another, and then we resolved the methodology for shifting things out of the base case and into the fuel rider. The other area where there was agreement, or maybe acknowledgement of Duke's position, because is for all these future-looking components of the fuel rider, right? The ones that are looking into next year, rates that are kind of the forecast of costs, the Duke's best estimate, those all are prospective, and those all are governed by Senate Bill 266. Does that answer your question?
It does, but I want to be very clear about this for the months, for the update period that we're talking about here, months of April, May, and June. Did you reach any agreement about whether those months in the 2026 fuel cost proceeding will be or will not be subject to Senate Bill 266?
I don't think we reached an agreement. Okay,
Okay.
I'm unaware of an agreement, but I would respectfully submit that the update period plus July 1st through 28th would be governed under the old law, which is going to be unwieldy, but the House and Senate spoke, and so that's my understanding of the public staff's position. And if I've conveyed something differently, I apologize.
Well, I just wanted to be clear, and I'll ask Duke the same question. So talking about the 2026 proceeding that we're not here to talk about, but it does implicate, issues are implicated for 2026. If the 2026 fuel cost proceeding, if it's bifurcated essentially about treatment of costs in 3 months, April, May, and June of 2025 are not subject to 266, and then the remaining months of the test period are subject to 266. What are the practical difficulties for both Duke and the public staff in bifurcating treatment of those costs?
Well, first off, I'm hopeful Duke will forego those last 2 days in July to make the books easier because they file by month. And so in the 3 months of the update.
I'm sorry, I should have said April, May, and June.
I understand.
Yeah.
For the 3 months of the update period and the 1 month of the next test period, those 4-month periods, right? What are the practical, how tough is it going to be to audit? It'd be a lot easier if it was all governed under one law. I readily submit that. But the legislature didn't say do what's easiest. The General Assembly said July 29th. We're experienced with the old law. We've been using it for coming on 40 years now, right? So I think that part will be easy to audit. We'll just do what we've always done. The new law has a much different recovery mechanism. And I think I have an understanding of it, but I think we'll all be kind of learning together, if that makes sense. I expect that, as I read the statute, that we'll be able to come into some alignment with Duke on how to treat the 11 months and 2 days of the part that does fall under Senate Bill 266. And I hope to, I'm not trying to, I think that the law kind of lays out a mechanism, right? It's like, hey, you make these numbers. And so I think it'll be a little bit hard, but you just got to do it because the General Assembly told us to.
Mm-hmm. Well, let me give you a different scenario too that these are obviously hypotheticals, but I think they do matter because we're going to have to figure out 2025 and 2026. But for 2025, if the commission, and I'm saying if, the commission were to agree with the public staff that April, May, and June of 2025, the update period, is not applicable to treatment from Senate Bill 266. And then if the commission thought that the entirety of the fuel cost proceeding in 2026 is subject to Senate Bill 266, I think Duke's argument is that there will be different treatment for prudency review. And you can't consider those 3 months in this proceeding not applicable to 266 and then potentially consider them to be applicable to 266? Like you have to do it. Is it your understanding that that 266 either applies to those 3 months in both proceedings, or it cannot apply to those months in either? Is there a way to do both? Does my question make sense?
It does make sense. Well, make sure my answer makes sense. The law focuses on the changes to the law. They're going to focus on when fuel costs were incurred. They don't really focus on the rider. Unlike Senate Bill 3, which I think might have talked about the riders, right? The law just said, hey, fuel costs incurred, treat it one way, treat it the other way. So the law didn't really focus on the rider so much as when the fuel costs would be incurred. And Section D of the fuel statute, where there's some changes about how we're going to have the balance going forward, it doesn't really impact the prudency review. We still have the, reasonable, prudent, incurred. That standard, I don't think changes by this law. I honestly didn't look at the law for that, but when I was looking at it, I didn't see that, if that makes sense. But the changes are kind of focused around, do you get interest, moving things from the base case to the fuel rider, shifting this, the balance of fuel going forward. They don't really take away the commission's and the public staff's right to review for prudency and reasonableness. So if your question's about prudency and reasonableness, I think that's going to maintain for this and next proceeding be the same standard. If your question's about what do we do with the rider, the legislature really addressed the costs and how they're treated less than the rider itself. Does that answer your question? I apologize, Commissioner.
So in other words, these 3 months, we have to either, for the 2025 proceeding and the 2026 proceeding, we have to either, for both proceedings, apply 266 or not apply 266. Or is there a way to not apply it in the 2025 and then apply it in 2026? I'm trying to understand, do we have any ability to apply it, not apply it in one proceeding and apply it in another proceeding? Does my question make sense?
I think that Senate Bill 266 is going to impact the next proceeding in 2 ways. The update period and the first 28 days of July are going to fall under the old law.
Okay.
I don't know that there's a solution other than that. And I don't think it's Will Freeman saying that. I think the General Assembly said that. They said, hey, effective when it becomes law. I'm not trying to not answer your question. I just want to make sure I understand.
Yeah, I may not have asked it very artfully, but I think you've given me enough of an explanation. My last question is just, can you just very succinctly explain why Duke's position that using historic costs to set prospective rates in a rider is not retroactive rate making, and that Senate bill, that 266 does not prevent them from setting prospective rates based upon historic costs?
That's the exact argument made in the Bollock case cited by Duke, the Wilson Ford Tractor case, and the Estridge case. And in those 3 cases, everyone made the same argument as Duke about, hey, I want to reach back here before the law and pull it forward in today's climate. The commission hasn't issued an order yet. My car lemon law issues arose after the statute. My bad contract with Ford still exists. My hand was injured by the machine beforehand. And I think that all those courts are telling us, look at before the law, look at what was going on. If it was a big thing, then that's when you got to apply. And if it wasn't a big thing, then you do it, and these are incurred costs. They're really big things. They're hundreds of millions of dollars. And the fuel reports that come out every month are like, they are spent. Like Duke wrote a check, that money's left their bank account. It's real, it's incurred. And so it's extremely substantial. It vested, it arose, it's a property right. And it would be disingenuous of me to say all $400 million should be disallowed because they're not real enough.
Mm-hmm.
And so because we have a very substantial event and then the law, you can't go back over that line now. That's what those 3 courts are telling us. So that's why it's impermissible for the retroactive.
Yeah, my last question is, I think a distinction with those cases and Duke's argument here is that Here, the commission is setting new rates. So that would be, I think, you know, an important distinction from the cases you've cited. Do you disagree with that?
That's the distinction Duke certainly would like to make is, hey, rates are all going forward,
Mhm.
but those rates are stemming from these costs, right? The part of the rates that isn't prospective, the part of the rates that's stemming from these actual incurred costs are the ones that are governed by the old law.
Okay.
And I cut you off, did I? I apologize.
So you answered my question, and thank you very much. That's all the questions I have. Let me check.
Thank
Let's
you.
see if there's any questions. Okay, Commissioner Tucker.
Mr. Freeman, what's the advantage for Duke monetarily to apply April, May, and June into 266?
The actual like short-term impact is like $2.7 million, which on a $1 zillion fuel rider is not a big number. I mean, it's a big number for me and you, but it's not a big number for Duke. In this case, I think maybe in the DEC rider, it's a bigger number. I don't know yet because we just don't know yet. But when they file, I think it's going to be a much bigger number. It'll be a little bit bigger number for Dominion. Long term though, big time, long term, years and years, it's not much impact at all because the legislature didn't add a lot of new things. They just moved things around and reallocated residential, commercial demand, energy factors. So very big picture is almost no impact, but short term, $2.7 million in this proceeding. My guess is many millions in the DEC proceeding.
So 2.7 million to the ratepayers.
Let me check, and we wrote it in our brief, and it's 2.1 or 2.7. Let me say more than 2 and less than 3, and I'll get you a number in about 5
Yeah, I
minutes.
always follow the money. Thank you.
Thank you very much. And there's no further questions, so we appreciate your oral argument.
Thank you.
Okay, and we'll move to Duke now.
Morning. Good to see you all. Thank you for this opportunity to speak to you on these topics. Commissioners, we view this as a very straightforward issue. A law was passed in July of 25. And the only disputed issue in this proceeding is whether we can apply a law passed in July of 25 to a fuel proceeding to be filed nearly a year after the enactment date of that statute. When you cut through the procedural complexities that are inherent in a fuel proceeding, that's the only dispute that we're here to talk about. And commissioners, if the General Assembly had intended that we should only partially apply the law to that future fuel proceeding, it could have made that clear. And in fact, in the past instances in which the General Assembly has amended the fuel statute, they did impose a limitation on the application of that law. But in this case, no limitation was included in the legislation. So when the General Assembly says this is how fuel proceedings in the future should run, we, of course, will fully comply and completely with every requirement of the law. We don't pick and choose which aspects of the law we should comply with in a future 26 fuel proceeding. We apply the entirety of the law to the entirety of that future fuel proceeding. So commissioners, you may be wondering, and we kind of touched on it here, why are we here in this 25 fuel proceeding arguing about something that's going to be applied in the 26 fuel proceeding? And it's a fairly straightforward issue, but I think it would help you to have this visual, which my co-counsel is passing out, and we'll give it a second to make sure everyone has this. And I shared this with Council of Public Staff in advance. So we'll give it a second to get those handed out. So this is just a very simple visual illustration of some key procedural elements to help show you and make sure it's clear to you, the commission, why we are here fighting about this issue if it's fundamentally a dispute about the 26 fuel proceeding. So as you can see in this chart, we are in the 25 DEP fuel proceeding. The test period for that proceeding is the second quarter of 24 through the first quarter of 25. In addition, in this proceeding, we have a supplemental update period. This is the important part. As Commissioner Kemmerer, your questions got to, this supplemental update period here directly is part of the test period for the 26 fuel proceeding. It covers the same period of time, or a portion of the same period of time. And so because Duke Energy's view is that the law should fully apply to the 26 fuel proceeding, which includes the 26 test period, we pulled that thread of logic through and said it should apply to the supplemental update period in this case. And that's important because supplemental update period is just an update in this case, but those costs are audited in the 26 fuel proceeding. So they're really technically part of the 26 fuel proceeding as well. So in summary, because it's our view that the law should fully apply to the 26 fuel proceeding, inclusive of the full test period, we also believe the law should apply to the supplemental update period in this proceeding. Commissioners, of course, we acknowledge and are not disputing that in applying the law to the 26 fuel proceeding, it will impact things that happened in 26, including things that happened prior to the enactment of SB 266. You can see that clearly on the chart. The test period for the 26 fuel proceeding extends back before the enactment date of SB 266. But this is the critical point. North Carolina courts have expressly stated that is permissible. Specifically, in a North Carolina Supreme Court decision that this commission has relied on in a past decision, the court stated that a statute is not rendered unconstitutionally retroactive merely because it operates on facts which were in existence prior to its enactment. And that is the exact outcome we are asking of the commission in this proceeding. We are seeking to apply the law to a future fuel proceeding, and the reality that such approach will operate on facts which were in existence prior to its enactment will not render that approach impermissible. Now, public staff's argument, as you've heard this morning, rests on alleging the company's approach is impermissibly retroactive, and Mr. Freeman summarized some of our views, a core part of our view on that issue, which is that we disagree that this is properly characterized as retroactive at all. Rate making is fundamentally a prospective activity. We are setting rates in a future fuel proceeding occurring nearly a year after the statute to apply rates that will be applied out in the future well beyond that fuel proceeding. And nearly all rate making has some type of historic period or backward looking element, but that fact does not make the rate making process a retroactive action to begin with. Commissioners, but even if you think there's a reasonable theory that what we're asking here can be properly characterized as retroactive, it's permissible, and here's why. The law is very clear that a statute is only retroactive where it impacts vested rights. Now, at a certain portion of Mr. Freeman's arguments, he sort of made it sound like the issue is whether it's a big thing or not. And Commission, that is nowhere in the case law on what a vested right means. Courts have been very clear on what a vested right is, and a vested right does not exist in this case or is not being impacted in this case. Vested rights almost always, if you look through the case law, always involve a clear contractual right, including a property right. So somebody's executed a contract between two parties. Those are vested rights, and there is no vested right being impacted in this proceeding. All of Public's case cited in their brief involve clear contractual vested rights of parties. Delaire Bank involves an executed loan agreement. Estridge involves a signed purchase agreement for an auto. Hicks involves an executed loan agreement and mortgage. Wilson involves an executed franchise. These are all parties that had executed an agreement, and the courts were saying we're not going to disturb an agreement entered into between two parties based on a law that was enacted after that agreement. That's not what's happening in a fuel proceeding, and it's not what's happening when you're setting prospective rates. In contrast, public staff has not cited a single example where a court has prohibited a commission from setting a forward-looking rate in a rate-making proceeding occurring after legislation simply because that rate-making period happened to have a historic test period. As this commission noted in the Cliffside decision, which I'm going to get to in just a moment, The proper question for consideration is whether the act as applied will interfere with rights which had vested. Stated otherwise, the statute may be applied retroactive only insofar as it does not impinge upon a right which is otherwise secured, established, and immune from legal metamorphosis. Commissioners, again, there is no vested right at stake in a 26 fuel proceeding. There's nothing in the 26 fuel proceeding that is immune from further legal metamorphosis. You have the authority to take the action that you're directed to do by the General Assembly in the 26 fuel proceeding. Under North Carolina law, there's no vested right in a particular tariff, let alone a vested right to a particular method for determining fuel costs or assessing test period costs. No vested right is being disturbed under the company's approach, and therefore there is no unconstitutional retroactivity occurring. So let's move to the commission's decision in Cliffside, because I think this is a very, very critical case for you all to understand as you think through these issues. All right, you had the Duke Energy received a CPCN. So this case involves Senate Bill 3. Mr. Freeman made reference to it. And it's a very important case for understanding how this commission has considered what it means to apply a law backwards in time and impacting facts that occurred prior to the enactment date of the law. So in this Cliffside proceeding, Duke Energy had already received the CPCN to build a Cliffside generating facility. They received that CPCN in March of 2007. After they received the CPCN, after they had taken actions under that CPCN, probably started purchasing equipment, started clearing the ground, Senate Bill 3 amended the CPCN statute and specifically amended parts of the CPCN statute that allowed for review of CPCN certificates. But that statute was made effective after almost a year after Duke Energy had received the Cliffside CPCN. Again, Mr. Freeman tried to make it sound like if it's a big thing, you can't, that somehow that matters, and it's a big thing, you can't touch it. A CPCN is a big thing. That was a very meaningful legal conclusion of the commission that directed the company to go construct a $100 million coal facility. So that was a big thing. Senate bill was passed. Senate Bill 3 was passed and amended the CPCN statute. And in a proceeding occurring before this commission after the effective date of Senate Bill 3, the commission fully, not partially, they fully applied that new CPCN statute amendment back in time and impacted the CPCN that was issued before the effective date of that statute. That is, the commission applied that new law fully, even though it impacted facts occurring prior to the law's effective date. And they did so citing the Supreme Court decision I quoted earlier. And let me quote for you further from the commission's decision in that Cliffside matter. And I'm going to paraphrase a bit the statutory references, but the commission said that the CPCN statute amendment by its very nature relates to a review of a previously issued certificate. There is nothing in the language of the CPCN statute to suggest that it only authorizes reviews of certificates that were issued after the effective date of the statute. This is key. So long as the review itself is conducted after the effective date of the statute. And that is exactly what we are urging in this case, commissioners. We are asking the commission to apply SB 266 to a fuel review proceeding occurring after the effective date of the statute. You could take that exact quote from your decision to Cliffside and substitute fuel statute for CPCN statute and fuel review for the CPCN review, and that's our exact argument in this case. The commission in its Cliffside decision said that what is crucial is when the review is happening. And that's so long as the review is happening after the effective date of the statute, the commission can and should and is obligated to reach back in time and touch facts occurring prior to the effective date. Public staff's pre-hearing brief gets this exactly backwards. They argue that the important time period is not the date recovery and review are requested, but is instead the date when the matters arose or occurred. That is 100% contradicted by what the commission did in the Cliffside decision when it states that what actually matters is that the review itself is conducted after the effective date of the statute. Senate Bill 3, which amended the CPCN statute we've discussed here at length, also amended the fuel statute. Mr. Freeman made reference to this as well. And I want to be really clear on exactly what the General Assembly said in there and why it matters for this proceeding. So Senate Bill 3 amended the fuel statute and it made those changes effective as of January 1st, 2008, but it did something further. It expressly provided that the changes to the fuel statute, I'm quoting, applied only to fuel and fuel-related costs occurred on or after January 1st, 2008, regardless of the test period established by the Utilities Commission. So I'll say that again. The Senate Bill 3 amended the fuel statute and it excluded this express limitation on how it wanted those fuel statute amendments to be applied. So why did the General Assembly include that in Senate Bill 3? Well, it's clearly included that because the General Assembly understood the changes they were making to the fuel statute, absent any further direction, would be fully applied to future fuel proceedings, including the full test period for such proceedings. And because in that instance, they wanted to limit the application to something short of the full test period, they expressly provided for it. They expressly imposed the test period limitation in the effective date of the statute. So the question for you is, did the General Assembly include an express test period limitation in Senate Bill 266? And of course, we know the answer is no. And why not? It's because they understood that their intent was for you to fully apply SB 266 to all fuel proceedings occurring after SB 266 was enacted. Now, I want to speak to one last issue before I close, and this relates to some criticism that public staff made of us in their brief, but it also touches on some questions, some very good questions Commissioner Kemright was asking of Mr. Freeman. From public staff's perspective in their brief, they criticized us for the alleged inconsistency of approach in this proceeding, the 25 proceeding, because as we've discussed, and I was glad to answer more questions on, we did not seek to apply SB 266 to the full test period of this 25 proceeding, even though the commission has not yet rendered its decision. And I want to be really frank on this one with you all, commissioners. We thought really long and hard about this issue. And commissioners, there is simply no doubt in my mind that the law requires that SB 266 should apply to the entirety of the 26 fuel proceeding. But frankly, I think there's actually a very good case to be made that for this pending proceeding, which was filed before SB 266, but for which your determination has not been rendered, that SB 266 should apply to the entirety of this case. And that was some of the questions you were getting at, Commissioner Kemright. And as I mentioned, we thought long and hard about that approach. But frankly, commissioners, we were very concerned about the challenges to the public staff about updating the entire test period in the middle of this proceeding. So while I believe we would have been on solid legal grounds to do so, we did not. But if you ultimately determine that we, and the commission is obligated to apply all of SB 266 in this proceeding because your decision has not been rendered, we of course will roll up our sleeves with public staff and carry that out. But I think what I want you to hear in that is beyond what does the law requires of you and of us, what I think you should hear in that is we were looking for a reasonable approach consistent with the law. From our perspective, we could have made the case to apply to the entirety of this case. We didn't, but we think it's indisputable that the law should be applied fully to the 26 fuel proceeding. And it's really public staff's view in this case that is not only inconsistent with the law, but it's extreme. Under public staff's position, a fuel proceeding occurring nearly a year after the statute, we still wouldn't be applying the law. And if you pull the thread on public staff's position, the fuel rates being charged in November of 27, nearly 2.5 years after the General Assembly enacted SB 266, would still not fully reflect what the General Assembly told us to do. There is no evidence that the General Assembly wanted partial application of its statute to fuel proceedings occurring after the effective date in that statute. Public staff has failed its burden, has failed to demonstrate that General Assembly wanted a piecemeal and extremely delayed implementation of SB 266. And Commission, for those reasons, we would ask that you adopt our position in this proceeding, and glad to answer any further questions that you may have.
Thank you, Mr. Drack. I'll begin. I appreciate, like I appreciated Mr. Freeman's oral argument. And I, again, am looking for legal consistency in argument and also, correct statutory interpretation. And I particularly appreciated your explanation about the decision about for this 2025 proceeding, because I'm very familiar with Cliffside. I've reviewed all of the case law that's been cited by both parties. I'm familiar with Cliffside, and the position, and it seems that the position that you've taken is inconsistent with your argument about the application of Cliffside, in that you are only applying, partially applying 266 to the 2025 proceeding, and that appears to be inconsistent with your argument, at least. The other question that I have is
Can I speak to that?
yes, please do.
So you're spot on that. Again, as I said, I think the most correct legal, if you're just saying, what does the law require us to do? I would tell you the law requires us to fully apply SB 266 to your decision in this proceeding, which will be issued after SB 266 was effective. So I think you're right in identifying that you could characterize us as being inconsistent. Again, as I mentioned, we thought a lot about that, and we tried to inject a little bit of pragmatism and reasonableness into that. But the law requires what it requires, and we could get that done if that's what this commission determines is the right and the obligation of the commission.
And to be clear, I'm in no way agreeing with your argument. I'm just stating what your argument is and your reliance upon Cliffside. I've heard the public staff's position as well. The other part of your argument that seems to be inconsistent is the argument that it is important to apply the entirety of the 2026 test period to the 2026 proceeding, where in the difficulties of review and the prudency review for the 2026 proceeding, whereas in this proceeding, it's being bifurcated, which is the 2025 proceeding is being bifurcated, where the test period is 266 is not being applied to the test period expenses, but 266 pursuant to Duke's request is being applied to the supplemental update period. Whereas I think public staff's position for 2026 would be that April, May, and June 2025 time period, 266 should not be applied to it, and the 2026 proceeding should be bifurcated. Why is it not problematic to bifurcate the 2025 proceeding, but it would be problematic to bifurcate the 2026 proceeding?
Again, we start with the law. What does the law require for the 26 fuel proceeding? And so our argument fundamentally hinges on what's right under the law, not what's too complex or makes the case more complicated. And then to that extent, I kind of agree with what Witness Freeman said. I would say in this case, the quote unquote bifurcation, if you want to call it that, is fairly easy to administer because we're not applying it at all to the test period. We are applying it to the prospective period. And that's pretty clean and easy to deal with in this proceeding. I think if you want to just focus on the complexity of administration, which again does not control, but it's the question you're asking. Our approach in the 26 proceeding makes the 26 pretty smooth. I would say theirs introduced public staff's position makes it more complex because you're splitting a test period up. So ours, in this case, we're splitting test period, billing period, and that's a little easier to administer conceptually and mathematically, from my understanding. In the 26 proceeding, theirs makes it really complicated because you're splitting a test period, and that is a little harder math, and you're going to introduce we're going to have 100 debates about did that check get wrote? If they reside with them, like, what does it mean when the cost was incurred? Did it mean the check had to clear? Did it mean the purchase agreement was signed? There's a lot of questions that are going to rise around that. So we think our approach, if you're putting aside the law and focusing on administrative fees, I think ours is actually still a better approach to public staff, to cleanly apply it to the full 26 proceeding and cleanly apply it to the 25 proceeding on a prospective basis,
Mhm.
which is exactly what we're doing.
And again, to be clear, I think our focus is on the legal application of 266, but I'm trying to understand the arguments about complication and difficulties. And one last question, that this is in witness DEP, witness Harrington's rebuttal testimony. And I'll just, it's on page 16, but I don't know that you need to turn to it because I'll provide that testimony. And the testimony said that it is important to apply Senate Bill 266 to the update period of the months of April through June of 2025, because the prudency review of those costs will occur in the 2026 proceeding. And I asked Mr. Freeman this question. I may not have asked it very well, but is it complicated, difficult, impossible if the commission do we have to apply 266 to those 3 months in the same manner in both proceedings? Or could the commission not apply 266 in the 2025 proceeding to the update period, but then apply 266 for the entirety of the test period? Do we have to do it the same way in both proceedings?
The commission could elect to not apply it to the supplemental update period and then apply it fully to the test period. I'm put one asterisk on that. I'll have to double check that. I'll correct myself if I'm wrong, if there's an accounting problem with that. But conceptually, you could, what you'd be doing was be pulling out some costs from the supplemental update period for this proceeding, but then pulling them back in for the test period. So yes, we believe the commission could do that if that's what they believe is the right outcome required in the law.
Okay.
And one thing I want to, sorry there.
No, I was just, the reason I was asking that question is I just want to have a full understanding of the difficulty that witness Harrington had mentioned in testimony so that I could understand that difficulty.
So I believe that could be an outcome the commission could adopt. And we've talked, Commissioner Tucker asked about the cost. So I do want to speak to that very briefly. And it's important to know that the cost we're talking about, there are no new categories of costs. Mr. Freeman, I think mentioned this as well. There are no new categories of costs being authorized for recovery under the fuel statute. It's just the General Assembly moved around where they're recovered, and they importantly included a specific obligation for us to ensure a process by which we are not double recovering any costs. So wherever the commission lands, we are sure that number one, we're not recovering any categories of costs that we weren't already entitled to recover. And number two, we're going to do the right work, the mathematical work necessary to ensure we're not double recovering anything between the base rates and the fuel rates. I just wanted that to be clear as well.
Okay, thank you. I believe that Chairman Brawley has some questions.
Yes. I want to talk a little bit about the way you used Senate Bill 3 from 2007 as a model for how Senate Bill 266 should be interpreted. And so let me start by saying that Senate Bill 3 was passed when Beverly Perdue was President Pro Tem of the Senate. Joe Hackney was Speaker of the House, and the majority of the legislature at the time was of a somewhat different political philosophy than the existing majorities in both houses. Phil Berger as President Pro Tem of the Senate and Destin Hall as Speaker of the House oversaw the majorities that passed 266. And unlike the previous, where Mike Easley signed the bill, in this case, veto was overridden. And I was thinking of a case recently, there were 2 rate cases for Duke Energy, BEP and DEC. The Attorney General filed a challenge basing the differences in those orders on capriciousness. during the debates, it was pointed out that there were 7 commissioners that voted on one, 4 in a majority, seeking a different rate of return. In the second case, there were 5 commissioners. The majority of 3 had dissented on the majority opinion in the previous case. And so the argument was made that it wasn't capricious, that the rate cases were intentional and based on sound thought. And I'm wondering, this sounds like the opposite of that argument, where the way that one General Assembly in 2007 approached an issue would be binding on another General Assembly that approaches a similar issue a significant time later with what I would say are some different views towards regulation. And so I wanted to raise that issue with you, so you got a chance to explain to me why we should expect that Destin Hall cares what Joe Hackney did.
Great history lesson there for us for sure. And, I would say I don't see this as, I follow the analogy you're making to the rate cases. And understand the analogy to the arguments that were made. I see these as a sort of fairly different question, though. The different decisions rendered in the rate cases, I don't know, we're close in time, and so there was, and as we argued, plenty of evidence to support the differing outcomes. And it's not a matter of one commission said one and one was silent on another topic in the second decision. It was just competing pieces of evidence in the 2 cases and a different makeup of the commission. Here, comparing Senate Bill 3 and SB 266, you have a sort of different fact pattern where you have a General Assembly who had a specific view about how the law was going to be applied temporarily and gave that temporal guidance. And I follow the point that says Destin Hall, Phil Berger are not studying the SB 3 to see exactly how they said it and then deciding how they want to say it in their law. But I do think it matters if the default reasonable position is the General Assembly wanted this law to apply to future fuel proceedings, which I think that's just kind of common sense. That without that limitation, it just further strengthens the common sense conclusion that they wanted you to apply the statute to a fuel proceeding happen after they passed the law. Like that, I don't think it's essential that you believe that Destin Hall and Phil Berger looked back to Senate Bill 3 and expressly decided not to include it. But the fact is, there is no limitation in their bill. And so without any limitation, I think your default plan should be, I'm required to take the law that exists at the time of my decision and apply it to the decision I'm making. And if there's nothing in their law that says, don't quite apply it fully, apply it in this way, then I think the reasonable common sense approach is apply the law as drafted, as enacted to your decision making.
If I could follow up on that, though, from the 2 arguments, as I understood, SB 3 authorized the commission to reach back and change things that had happened previously. And this is not a case of changing something in the past, it's being specifically authorized. And that order to change the past, if you will, specifically written in SB 3, was not just a permission, it was a mandate, I would say.
So are you talking about the CPCN statute amendment?
Yeah, yes, sir.
That's a great, and I want to be really clear on that. The law just gave direction about what it means to potentially review certificates. Nowhere did it say, we are directing you to apply certificates issued before this law was enacted. There is nowhere in the statute does it give that kind of direction that says, by passing this new framework for reviewing CPCNs, we want you to take this law and we want you to go apply every CPCN you've ever issued before this. That was not in the law. They passed a general provision saying you have the authority to review CPCNs, full stop. Commission made the logical step that said there is nothing in this law that prevents us from going back and touching facts that occurred before the law. So that's a very important distinction that I don't want to be glossed over. To just summarize, Senate Bill 3, there is nothing expressly in Senate Bill 3 that says the General Assembly was expecting that you would go back in time and touch laws. It just gave it set a new review process, full stop. And the commission's conclusion was, once the General Assembly has given us a new review process, we are obligated to apply it fully, even if we have to go back and touch facts that occurred prior to the enactment date of the statute. And that's exactly what we're saying in this case. General Assembly gave you a new way to do fuel proceedings. You are obligated to apply it, even if it means going back and touching facts that occurred prior to the enactment date of the statute.
I understand your point. Thank you.
Commissioner Tucker.
Thank you, Commissioner Kimwright. I guess if no one had been in proceedings yesterday or today, they would think that Duke does business retroactively on everything. I want to ask you, Mr. Durack, when a law has a date and it's enacted, what does that mean to you?
It means that the General Assembly has enacted a law, has enacted a policy direction, a structural change to the way in which review processes are to occur. And they are directing Duke Energy to comply with that and directing Commission to apply the new review process that it has established.
When you read a law, or this one particularly, do you see anywhere in the wording that it says it requires the implementation of this law to have the opportunity to read between the lines?
No, I don't see anything in the statute that says read between the lines, and I don't perceive that's what we're attempting to do here, but certainly glad to respond to further questions.
Well, would you agree that sometimes when the General Assembly enacts laws, there are things that are left out or ambiguous to what you would think should have been there?
I would never suggest that esteemed General Assembly members would pass an ambiguous law, but it does happen from time to time. And when it does, there's a whole canon of how a commission and courts can sort out what it is the commission or the General Assembly intended in an ambiguous statute. But we don't, frankly, see any ambiguity in the statute in this case.
Well, when I was in the General Assembly, the constantly use on certain laws was unintended consequences. And the consequences here seem to be that it was not well defined, and you are supplanting the law by saying that the law says you should go back prior to 7/29 to implement the new fuel rider law. Whereas if you didn't have 266, you would be implementing the old fuel rider law. I just don't quite understand why you're reaching back when you've got the law in front of you and thinking that the General Assembly is supposed to say to Duke, and they should have, that you either don't or you do go back. And it should be clear in the law, and we wouldn't be here today. So I give that. I understand that. One other question, if I may, and you can respond to that as well. I asked Mr. Freeman what the advantage was to Duke monetarily for going back and capturing those 3 months prior to 266 being passed. Can you state again what the dollar amount would be and what impact it would have on the ratepayer?
I believe the number cited by Mr. was in the ballpark of correct for this proceeding. I don't have the number for me in front of me for the DEC proceeding. But again, I would emphasize that what this relates to are purchase power agreement costs that have always been recoverable.
Right.
Just a matter of where they're recovered. And we have the direction from the General Assembly to ensure no double recovery. So the substantive outcome from applying the law in the way we have advocated for results in recovery of prudent and reasonable costs that were needed to keep the lights on in the state of North Carolina. So from our perspective, that's not an unreasonable substantive outcome to occur in this fuel proceeding. And again, we got a mechanism to ensure no double recovery, and there'll be a full audit of those costs in the 26 fuel proceedings. So if there's any concerns with any of the costs, they'll have a fulsome opportunity to audit them. But again, from our perspective, the law requires what it requires, but it's a reasonable outcome for us to be able to recover costs that we incur for customers.
Okay, so back to my original question. What difference does the enactment date of a law make? And its lack of clarity or clarity in your review of 266?
Again, I would reiterate our position that the effective date of the law is the General Assembly saying from this point in time onward, we want you to conduct this rate-making proceeding in accordance with this new law. I mean, what I would remind you is that all rate-making proceedings have an element of a historic test period.
I agree.
So if the commission had passed a base rate case law on July and we had filed a base rate case in August, you would have had to have a test period well before the effective date of the statute. You would have had to reach back in time and touch facts that occurred before the enactment of the statute. That is just what rate making is. It is a prospective process that involves, in part, a historic test period. And in that base rate case example, hypothetical, there's just no way around it because base rate cases are totally historic test period. So under public staff's view, you almost couldn't use your new rate case statute until a year and a half later, once that full test period has moved past the effective date of the statute. That's obviously not what would have been a reasonable outcome. So every rate-making proceeding is setting prospective rates. Every rate-making proceeding has some elements of looking backwards in time. When the General Assembly says, as of this date, we want you to use this new process, there's no way around using that process entails some element of reaching back and touching facts from the past. But that is not prohibited by the law. And the General Assembly, again, respecting Commissioner Brawley's perspective, knew how to say, we don't want you reaching back and touching facts from a historic test period. And they didn't say that here. So I think the best conclusion is that we need to apply the law as it's drafted for fuel proceedings occurring after the effective date of the statute.
Thank you for that explanation. Circling back around, what, with the new fuel rider law from 266, and you apply that to April, May, and June, once again, your reason for doing that is you're able to capture additional dollars, and what is that amount, if that's the case?
In the DEP proceeding in the second quarter, I believe the number is just short of $3 million of reliability capacity purchases that were incurred to keep the lights on peak periods on the system. So we, again, from our perspective, the ask is supported by the law, but it's also a very reasonable one to say that those costs were incurred for the benefit of customers and should be recovered.
So if 266 didn't pass, you would not be able to recover the additional $3 million.
Correct.
Have no further questions?
Okay. Okay. That's the end of commission questions. Thank you, Mr. Drack, and I want to thank both Mr. Freeman and Mr. Drack for excellent and very professional oral arguments. It was appreciated by the commission. So with that, we will now proceed with the expert witness portion of the hearing. And before we get started with the expert witness portion, are there any preliminary matters that need to be addressed? We will be taking motions for filings to be entered into the record in just a couple of minutes. But any other preliminary matters before we do that? Okay. And before we begin, I will say a few words regarding the process for this proceeding. It is the commission's intent to conduct this hearing in an efficient manner. Toward that end, I remind the parties that witnesses should not read their testimony summaries into the record. Moreover, parties should monitor questions carefully and avoid asking repetitive questions of witnesses. When making motions to enter cross-examination and redirect exhibits into the record, please identify the exhibit by its potential exhibit number first. This allows the parties and the commissioners to access the hard copy or electronic copy of the exhibit. Once the exhibit has been located, please identify the exhibit for identification purposes, and then I will identify it as well. The parties may make motions to have the exhibits entered into the record at the conclusion of the witness's testimony. After the commissioners have asked questions of the witnesses, the attorneys will have an opportunity to ask questions that are specifically related and limited to the commissioner's questions. Any attorney that wishes to ask questions on commissioner's questions will be required to first identify the commissioner that asked the question and then restate the commissioner's question before asking his or her question. And we will proceed with the expert witness hearing, but first we will take a 10-minute break. And we will go off the record. We will come back on the record at 10:32. Thank you. Okay, let's go back on the record and let's begin with motions from DEP, please.
Thank you, Presiding Commissioner. At this time, I'd ask that the company's application be moved into the record.
Okay. Are there any objections from the parties? Seeing no objection, the application relating to fuel and fuel-related charge adjustment consisting of 5 pages filed on June 10th of 2025 will be entered into the record.
I'd also ask that Ms. Harrington's pre-filed direct testimony consisting of 16 pages, 1 appendix, 9 exhibits, and 16 work papers also be moved into the record as if orally given from the stand.
Okay. Are there any objections? Seeing no objections, the testimony will be entered into the record as if given orally from the stand.
I'd further request that Ms. Harrington's supplemental testimony consisting of 9 pages, 1 revised appendix, 7 revised exhibits, and 5 revised supporting work papers also be moved into the record as if given orally from the stand.
Okay. Are there any objections? Seeing no objection, the supplemental testimony will be entered into the record as if given orally from the stand.
And finally, ask that Ms. Harrington's summary of her direct and supplemental testimony, also pre-filed with the commission, be moved into the record
Okay.
as if orally given from the stand.
Seeing no objection, the summary of the testimony will be entered into the record as if given orally from the stand.
Thank you. Nothing further.
Okay.
Yeah. Presiding Commissioner Kimmerite, if I may, there was another panel of 2 witnesses, Mr. Flanagan and Mr. Swez, as part of the company's direct case where there's also not any time for cross-examination that has been reserved. So if it's okay with the commission, I would ask to move those direct testimonies and exhibits and I can walk through them similar to Ms. Harrington. So Mr. Flanagan's pre-filed direct testimony consisting of 11 pages, I'd ask that to be copied into the record as if given orally from the stand, and he did not have any direct exhibits.
Okay. Seeing no objection, that testimony will be entered into the record as if given orally from the stand.
Thank you. Mr. Flanagan also pre-filed a summary of his testimony that I would ask be copied into the record as if given orally from the stand.
Seeing no objection, the summary of the testimony will be entered into the record as if given orally from the stand.
Thank you. And then turning to Mr. Swez, Mr. John D. Swez pre-filed 12 pages of direct testimony as well as 3 exhibits, and I would ask his 12 pages of testimony be copied in the record and his exhibits be accepted as hearing exhibits in the proceeding.
Okay. And for clarification, Exhibit 3 is marked confidential. Is that correct?
Yes, ma'am, that is correct.
Okay. So the direct testimony of DEP witness Swez consisting of 12 pages will be entered into the record as if given orally from the stand. Are there any objections to entering the 3 exhibits into the record? Okay. Seeing no objection, the 3 exhibits attached to Mr. Swez's direct testimony will be entered into the record with the notation that Exhibit 3 is confidential.
Thank you. Mr. Swez also pre-filed a summary of his direct testimony, and I'd ask that also be copied into the record as if given orally from the stand.
Okay. Seeing no objection, the summary of Mr. Swez's direct testimony will be copied into the record as if given orally from the stand.
Thank you. And those witnesses will be available for cross-examination on their rebuttal testimony at the appropriate time.
And so for clarification, direct testimony of witnesses Houston and McNeil.
I believe that the order did move the direct testimony of Mr. Houston and Ms. Neal into the record, but for
Okay.
clarity's sake, I request.
Okay. Over an abundance of caution, seeing no objection, the direct testimony of DEP witness Houston consisting of 9 pages with 2 exhibits filed on June 10th of 2025. The direct testimony will be entered into the record as if given orally from the stand, and the 2 exhibits will also be entered into the record. Additionally, the direct testimony of Kelly S. McNeil consisting of 4 pages will also be entered into the record as if given orally from the stand.
Thank you. And in that same spirit, we also ensure that witness Flippin's direct testimony is also moved into the record.
Okay. Again, out of an abundance of caution, seeing no objection, the direct testimony of DEP witness Flippin consisting of 13 pages with one exhibit, and I will note that that exhibit is marked confidential.
That's correct.
The direct testimony will be entered into the record as if given orally from the stand, and the one exhibit that's marked confidential will also be entered into the record.
Thank you.
And were summaries of testimonies, were there any summaries of testimonies filed as well? My
Yes,
recollection.
there was testimonies filed as well for witness Flippin, witness McNeil, as well as witness Houston.
Okay. So seeing no objection, the summary of a DEP witness Houston's direct testimony will be entered into the record as if given orally from the stand. The summary of DEP witness McNeil's direct testimony will also be entered into the record as if given orally from the stand. And the summary of DEP witness Flippin's summary of his direct testimony will be entered into the record as if given orally from the stand. And I think that covers all of the direct testimony and supplemental testimony for DEP. Is that correct?
That is correct. Thank you.
Okay, and with that, I think we can move on, is that correct, to the interveners. And we will begin with let's begin with NCSEA. Okay.
Presiding Commissioner Kemmerite, at this time, NCSA calls Albert Lynn to the stand.
Good morning, Mr. Lynn. If you can place your left hand on the Bible and raise your right hand, and do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you.
Good morning. Could you please state your name for the record?
Yes, my name is Albert Lynn.
And can you please state your place of business and role?
Yes, I am a consultant to NCSEA. I conduct business from 26732 via La Jolla in San Juan Capistrano, California.
And Mr. Lynn, did you cause to be filed on September 2nd, 2025, direct testimony consisting of 38 pages and 10 exhibits?
I did.
And did your testimony contain any confidential information?
Yes, it did. Pages 27 through 31 contain confidential information, and exhibits 6, 7, 8, and 9 also have confidential information.
Thank you. And do you have any changes or corrections to your testimony at this time?
I do not.
And if I were to ask you the same questions today from the stand, would your answers be the same?
They would.
Did you also cause to be filed in docket E2 sub 1358A a summary of your testimony?
Yes, I did.
Thank you. Presiding Commissioner Kemmerite, I request that the pre-filed direct testimony of Albert Lynn and its summary be moved into the record as if it was given orally from the stand.
Good. Are there any objections? Seeing no objection, the direct testimony of NCSEA witness Lynn, consisting of 18 pages, filed on September 2nd, 2025, will be entered into the record as if given orally from the stand.
Thank you. And Presiding Commissioner Kemmerite, I also request to pre-mark for identification purposes NCA witness Lynn's exhibits 1 through 10 as marked when pre-filed.
Okay. Seeing no objection, the 10 exhibits attached to NCSEA witness Lynn's direct testimony, noting that exhibits 6, 7, 8, and 9 contain confidential provisions, will be identified as pre-marked.
Thank you. At this time, Mr. Lynn is made available for cross-examination and commissioner questions.
Let me make sure, did you request that the summary of his testimony be entered into the record?
I did. I believe I did, but out of abundance of caution, I'll request again to move the summary of the direct testimony of Albert Lynn into the record.
Okay. Seeing no objection, and you may have already made that motion, but seeing no objection, the summary of witness Lynn's testimony will be entered into the record as if given orally from the stand. Okay. So we will move to cross-examination. I believe that DEP had reserved some cross-examination time, but had indicated that you will be waiving cross-examination. Is that correct?
That's correct. And we informed counsel for NCSEA at the start of the hearing yesterday that we were foregoing our reserve time. Thank you.
Thank you. So there are no, there's no further cross-examination from the parties. Let me check to see if any of the commissioners have questions of the witness. Okay. There are no questions from the commission. I appreciate you coming to the hearing today and being available for answering questions. With that, you may step down and be excused. Thank you.
Okay.
This time I'll take motions from you in regard to exhibits.
Okay,
Okay.
thank you. Presiding Commissioner Kimmerer, at this time, I request to move witness lens exhibits 1 through 10 into the record, again, noting that exhibits 6, 7, 8, and 9 are confidential.
Okay. Seeing no objection, your motion is allowed. Thank you. So we will now move to SACE.
Thank you, Presiding Commissioner Kimmerer. At this time, SACE et al. Would call witness Michael Goggin to the stand.
Good morning, Mr. Goggin. Okay. You can raise your right hand and put your left hand on the Bible and raise your right hand. And do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Thank you.
Good morning. Please state your name, title, and business address for the record.
Sure, it's Michael Goggin. I'm with Grid Strategies. I'm the vice president there, and my business address is 4704 Blagden Terrace Northwest, Washington, D.C.
And please briefly describe your roles and responsibilities at Grid Strategies.
Sure, I've been there for about 7.5 years. I'm a consultant to a range of parties that are interested in power system operations and transmission. Clients include state utility commissioners, commissions, grid operators, public interest organizations, and independent power producers.
Mr. Goggin, on September 2nd, did you cause to be pre-filed in this docket direct testimony and 2 exhibits collectively consisting of 31 pages?
Yes.
And on September 25th, did you cause to be pre-filed in the E-2 sub 1358 docket a summary of your testimony consisting of 4 pages?
Yes.
Presiding Commissioner Kimmerer, at this time, I would move to have Mr. Goggin's pre-filed direct testimony and testimony exhibits, which collectively consist of 31 pages, along with his pre-filed testimony summary, which consists of 4 pages, to be entered into the record as vote given orally from the stand, and to have those exhibits attached to his pre-filed direct testimony identified as pre-marked.
Are there any objections? Seeing no objection, the direct testimony of SACE witness Goggin filed on September 2nd of 2025, consisting of 26 pages, will be entered into the record as if given orally from the stand, along with a summary of his testimony that was filed on September 25 of 2025. The 2 exhibits attached to witness Goggin's direct testimony will be identified as pre-marked.
The witness is available for cross-examination and questions from the commission.
I believe that DEP has reserved cross-examination time for this witness.
We have, thank you. Good morning, Mr. Goggin. Brett Bryce, on behalf of Duke Energy Progress. How are you?
I'm good.
Good.
Good morning.
Good to see you this morning.
Yeah.
All right, I'd like to start just with a couple of background questions. When you were introducing yourself in your prepared remarks this morning, a little bit different, but on page 1, lines 12 and 13, you address your background and interest, and you say you are a testifying expert at Grid Strategies, testifying on a range of clients interested in clean energy. Do I have that correctly?
That's correct.
Okay, so predominantly that's the area of your expertise and focus are clean energy issues.
It includes that, but then, and that is probably the bulk of our clients, but then, I've also done, 20 years of work in power markets and electricity transmission.
Okay, and turning to page 2, you've testified twice before this commission before, is that correct?
That's correct.
And that's addressed at the bottom of the page. You referenced 2 dockets. The first was E7 sub 1276, which was DEC's MYRP rate case in 2023.
That's correct.
And then the E100 sub 190, which was the Duke Company's carbon plan or CPRE proceeding in 2024.
That's correct.
And is it fair to say in both of those dockets, your testimony was exclusively focused on transmission planning and advocating for proactive transmission investments to more cost effectively integrate solar, other clean energy resources into the Duke company's grids?
For the MYRP case, that was the exclusive focus. I believe the carbon plan I did touch on gas reliability risk and economic risks as well, but the bulk of my testimony was on the transmission planning.
Okay. And is it accurate that this is the first time that you've testified in a fuel cost recovery proceeding here in North Carolina?
It is, but I have in other states.
Okay. And which states are those?
Virginia, most recently.
And when was that?
Several months ago. The hearing was earlier this month, and then I have filed written testimony in Arkansas in a fuel case as well.
Okay. And who were those testimonies on behalf of?
The testimony in Virginia was on behalf, it was a coalition for Southern Environmental Law Center was the client that hired me, and then I would need to check the exact, I don't want to, I've gotten this
That's
exact
fine.
case confused. I want to give the exact client name, but it was some overlap in the clients, I believe. In Arkansas, the client and the interest is the Audubon Society.
Okay, thank you. And so your testimony in this fuel proceeding for DEP is focused on the company's unit commitment and dispatch process specifically for its coal units. Is that accurate?
That's correct.
Okay. And just you've never been employed by a utility that owns, operates, dispatches coal generation, correct?
That's correct.
And based on reviewing your testimony and background, you've never planned, consulted, or supervised the unit commitment process of a utility's generation fleet, correct?
That's correct. I've done work on at RTOs on designing, commitment processes and, through the stakeholder proceedings and things like that, but not at a utility.
Okay. And have you reviewed the rebuttal testimony filed by call it the Duke Operations Panel?
Yes.
Okay. And you saw a reference, I think we'll attribute this to Mr. Swez, of the use of GenTrader as the production cost model that DEP uses to plan and execute its 7-day unit commitment process.
Yes.
Do you have a license to use the GenTrader production cost model?
I do not, but I'm generally familiar with production cost models and what they do.
Okay. And is it accurate that you're not certified by NERC as a system operator?
That's correct.
Okay. And so you've never managed the real-time dispatch of a generating fleet in the past, correct?
That's correct. I've served as an expert on operational matters, but I've not done it myself.
Okay. Turning now briefly, how many coal units does DEP own and operate?
There are 5, I believe, at issue in this case, the 4 Roxborough units and the Mayo unit.
What are the total capacity of those units?
It's about 3,300 megawatts nameplate, about 2,500 megawatts at the 4 Roxborough units, and about 750 at Mayo is my recollection.
Okay. And based on your operational experience, how long does it take to ramp up a coal plant?
So that is in this proceeding, but I believe it's confidential, so I can't get into the specifics for these units.
Well, that's good. Keep me out of trouble as well. In general terms, based on industry experience, not specific to these units, would you agree that it takes days, not minutes or hours?
Startup times for coal plants are generally less than a day, but around a day can be a benchmark. Some are less, some can be more, but generally less.
Okay. And so you said through your testimony, you presented an analysis where you articulate coal unit dispatch fuel costs essentially that you have deemed to be imprudently incurred. Is that correct?
Yes.
Okay. And so you did that essentially on an hour by hour basis over the test period in this case. Is that accurate?
That's correct. And that incorporated the startup times, the precise ones that are provided by the company in the confidential discovery. So that was incorporated, the startup time was incorporated fully into the analysis as a limiting constraint.
Okay. And I think you said that you reviewed the company's rebuttal testimony in this proceeding.
Yes.
And I want to refer you to page 17 of their rebuttal testimony. If I
Okay.
could here, do you have it here? I can provide you a copy if you.
That would be helpful. Thank you.
Yeah, sure. If you've got a clean copy, that would be great. I've got an extra copy, but it's marked up.
Can you identify the rebuttal testimony that you're referring to so that we can all be clear about that?
Yes, ma'am. This is the rebuttal testimony of Duke's operations panel, which is Mr. Swez, Mr. Flanagan, and Mr. Lloyd.
Presiding Commissioner, if I may, just for counsel for Duke, is this going to be the entirety of the rebuttal testimony or just a excerpt? If it is an excerpt, I'd just ask for a copy, if possible.
Witness?
Yeah, if you're giving in the entirety of the testimony, that's fine. But if it's an excerpt, I'd just like a copy just for my own reference too.
Page 7. I have 2 copies. See, this is the second copy that has some pre-marking on it.
Sure. Yeah.
One of those.
Yep. Great. Okay, thank you.
So, yeah. Oh, shoot. All right. So starting out, page 17 of the rebuttal testimony of the operations panel, which you said you have reviewed and are generally familiar with, correct?
That's correct.
All right. And so this is one of the areas where the Duke company, or DEP, excuse me, the Duke operations panel is reviewing your proposed disallowances, which were prepared on an hour-by-hour basis, and identifying concerns with your allegations that it was imprudent to have coal units operating during specific hours because, as your analysis presented, it exceeded system lambda cost. Is that accurate?
The bulk of the analysis was done on system lambda, but we also did a validation and redid the entire analysis on using PJM day-ahead prices for the PJM South Zone, which we also obtained from the company through discovery. And we did that validation to, I think, address some of the concerns about lambda, and basically because the day-ahead price is set day-ahead, so it incorporates the imperfect foresight that the company has in that day-ahead time commitment when it is making time period when it's making commitment decisions. So we did the analysis both on lambda and on PJM prices as well.
Okay, but you would agree that the company doesn't operate in PJM. They're not in that RTO, correct?
Absolutely, but in our analysis we showed that there was a close track between system lambda and Duke system lambda and PJM South hub prices, and so we thought it was a useful metric of real-time marginal value or cost of generation.
Okay.
Yes, we recognize that you are not in PJM, and that there are strong transmission ties between here and there, but it is not, they don't track perfectly, but they were very close in terms of the prices move together and they have a similar average.
Yeah, and you didn't evaluate or include in your analysis the transmission cost to deliver the power from PJM to DEP, correct?
That wouldn't have been appropriate here because what we're looking for is the measure of marginal cost or marginal value, and on Duke system, and the PJM price is simply a proxy for that because there is a price there that we can publicly see.
Okay, so the extent of the value of your PJM analysis is just to provide a proxy. Is that accurate?
It was intended to be a validation that addresses many of the concerns I think that the company has raised about using system lambda, including the system lambda reflects the instantaneous incremental cost, not the more full cost that incorporates the multiple days. It also is a day-ahead price, and so it has that imperfect foresight that the company does have when making commitment decisions. So It also includes PJM co-optimizes between the energy and ancillary services markets. So operating reserve needs and their impact on price are incorporated into the PJM price. So for a number of reasons, we thought it was important to use that validation to address the company's concerns about system lambda as a metric of marginal cost or marginal value.
Thank you. And just to confirm the record's clear, you did not include in your analysis what the cost would be to deliver power from PJM to the DEP system, because DEP is not in that RTO, correct? There's no consideration of transmission or whether it was feasible, whether there was an incremental cost in terms of assessing whether it was appropriate to have the DEP coal units operating during these hours, correct?
That's correct, because that was not the point of the analysis. The point of the PJM price analysis was to, at the closest pricing node that's available, or the closest pricing hub that's available, to assess what was the marginal cost or marginal value of energy in the day-ahead time frame as close as possible to Duke's system. Obviously, there is no day-ahead price here.
Okay. And you didn't identify specific generators in PJM that would have been capable of delivering power to DEP during the hours where you determined that it was imprudent to have these coal units operating, correct?
That's correct for a few reasons. First of all, PJM doesn't disclose individual generator bids due to market manipulation reasons. Second of all, that wasn't the point of the analysis for the reasons I just explained, that we're just simply looking at what is the marginal value, marginal cost of energy in the day-ahead time frame. So no.
Thank you. All right. So I want to return back to North Carolina and the company system that we are operating in today. So just to confirm, one of the periods that your analysis determined that Duke's operation of its coal units and the associated fuel costs was imprudent was July 1st through 5th of 2024, correct?
That's correct.
Okay. And were you aware that July 5th was the single hottest day on record in Raleigh at 106 degrees Fahrenheit when you prepared your analysis?
Probably not when I prepared the analysis. We were looking across the entire year and looking at lambda and price. And, it would have been factored into the lambda and the price if it was, that high demand. But we did not. I don't think I was aware of that at the time.
Okay. And is it accurate based on your assessment or based on the company's review of your assessment that up until July 5th, with temperatures approaching 106 degrees, your analysis said it was uneconomic and not prudent for Duke to have any of its 5 coal plants, 3,000 megawatts, to be operating during that period of time, July 1 through 4. Is that accurate?
And through July 4th, that's correct. Yes.
Okay. And then on July 5th, you determined that it was prudent to operate 2 of 5 coal plants, so approximately 1,500 megawatts, but it was imprudent to operate 3 of 5 coal plants, which were Roxborough units. I guess you found that operating units 2 and 4 was prudent, but it was imprudent to operate the other 3, so 1,581 megawatts. Those should stay offline. Is that your testimony?
That sounds correct, yes.
Okay. And then would you agree with Duke's testimony that you did not consider day-ahead operating reserve margin in your analysis?
That's not totally correct. What we did for 2 reasons. As the company explained in its recent discovery responses, there are many interactions between system lambda and operating reserve needs. Running a unit to provide operating reserves can reduce system lambda because that resource is also going to produce energy. At the same time, holding a unit's output back from its full capacity can also affect lambda. It withdraws energy, and that can, then increase lambda. So there are interactions between operating reserve needs and lambda that are accounted for in the lambda. As I mentioned a minute ago, this is another reason why we did the PJM price validation. As I mentioned, PJM co-optimizes its energy and operating reserve markets. And so operating reserve needs are fully factored into the PJM price. So that was part of the reason why we did that validation as well.
Thank you. I don't have any further questions.
We'll turn to redirect from SACE.
Just a couple questions. Mr. Goggin, can you just discuss generally your familiarity with power plant economics and unit commitment practices?
Yeah, so the general method that all grid operators in RTOs and outside of RTOs use is in the day-ahead time frame, there's a decision typically made about which plants will run the next day. And this gives long lead time resources like coal units time to start up. For gas units, it gives the operator time to buy gas and make those arrangements. And then as you move between that day ahead and the real time, there's kind of a truing up as supply and demand come in slightly differently, typically than was expected day ahead. In an RTO, this is done through a real-time market. Outside of in vertically integrated utilities, it's done through system operations. There's this truing up as supply and demand fluctuate to fine-tune that supply to meet the demand. And then operating reserves are used in the very minute-to-minute time scale to really finally true up supply and demand.
Thank you. And you touched on this a little bit during the cross-examination, but can you discuss in a little bit more depth what sort of information is conveyed by System Lambda?
So System Lambda is the instantaneous cost, or the marginal cost of the highest cost unit that was needed to meet electricity demand. And it's for that reason, because it's an instantaneous incremental cost, it does not perfectly reflect the decision that should have been made the day ahead. And that's why we did the PJM day ahead market price validation, because that is the information that was fully available the day ahead on the marginal cost or marginal value of energy, accounting for that imperfect foresight that you don't know exactly on a day ahead basis what your load is going to be. Sorry, can you repeat the question? I got.
Yeah, and maybe just as a follow-up question, please convey what information about supply and demand are conveyed by System Lambda.
Yes, so that jogs my memory. So both System Lambda and the day ahead price is intended to convey the marginal cost or the marginal value of energy. And the intent is to assess the economics of in this case, the coal units relative to that marginal value. And basically the idea is that if the coal unit is higher cost than the marginal value of the energy it's providing, it was not economic to do that, to run that unit. There was another resource setting that marginal price or their marginal cost that could have provided that energy and would have been more economic to do so. This is on my memory. There was another point I wanted to make about Lambda is that because it is an instantaneous measure of marginal cost, our analysis also looked at the counterfactual case to account for the startup costs, factoring the startup time and these other operating parameters that we got from the company through discovery. And our analysis is comparing what the company did, which was generally running these coal units, against this counterfactual where the coal units were turned off for periods of time and then restarted. And so our analysis fully accounts for that startup cost, the startup time, all of these constraints in our counterfactual. And the net cost that we report in our analysis is the delta between those. And so we do, basically, we're handicapping our number. We're making this counterfactual case less attractive by fully accounting for the startup cost and saying, yes, if you did turn this coal unit off and then turn it back on, there's a cost associated with that. And we are accounting for that in calculating the disallowance. And so I think that responds to many of the company's arguments that Lambda is an imperfect measure because it's only incremental cost at that moment. It's an instantaneous incremental cost. Our analysis is fully looking at over multiple days what is the full all-in cost of starting the unit, turning it back off, turning it on again. All of that is accounted for in our analysis.
And you anticipated my counterfactual redirect question, so I appreciate that. I think one last redirect question I have for you. There was some discussion about the day-ahead operating reserve requirements for the DEP system. Can Can we talk a little bit about some of the constraints with using coal units as, I guess, day-ahead operating reserve resources, for lack of a better word?
Sure. So the way operating reserves are typically handled is it's also done economically. You look at which resources have the flexibility to increase or decrease their output to provide the various types of operating reserves that are needed. And then there's a selection of those resources, choosing the lowest cost resources to do that. And a large share of the operating reserve need is non-spin resources. This is needed for contingency reserves. Basically, if a large unit goes down, typically a large coal, combined cycle, or nuclear unit goes down, NERC rules require that unit's output to be replaced in a relatively short period of time. And that's typically the requirement is that you must synchronize the resource within 10 minutes and then fully replace your reserves within 30 minutes. And so this is typically done by non-spinning resources, which is in most cases a combustion turbine that's sitting there, not operating, but you can start it up in less than 10 minutes and have it fully ramped up in time to provide that. And so combustion turbines provide a significant share of that non-spinning reserve. The remainder is provided by operating units, typically spinning reserves. And this is also used for the fast fluctuations in supply and demand. Coal units are generally not flexible enough to provide super fast, second to second, minute to minute accurate operating reserves. Gas generators are much more flexible in this regard. And so in many cases, gas units kind of take the lead in providing these faster operating reserves. We asked the company through discovery if they had data that they could provide on which units provide operating reserves. Through counsel, they objected and indicate also that they don't track that or have that data. So unfortunately, we weren't able to analyze that. But as a general matter, I can say that due to their relative slow and inflexible response, coal units are less favored in providing operating reserves. I will say, however, that if also there's a large fleet of resources that can provide these operating reserves. It could include coal plants, could include gas plants, pumped hydro, obviously batteries as they come in. All of these can provide operating reserves. And so if the company were using coal units to provide operating reserves, if in our counterfactual we then decommitted those coal units, it would be very easy to go out and look at the other resources that are available, maybe at a marginally higher cost, and use those to provide whatever operating reserves they may have been. But as a general matter, I don't believe that, we don't know what units actually do provide the operating reserves, but in most cases, the gas generators are carrying a large share of that responsibility.
No further redirect.
Okay, thank you. I will then turn to questions from the commissioners. Commissioner Tucker.
Thank you, Commissioner Kimwright. Mr. Goggin, you've testified here before, have you not?
Yeah.
Yeah, I remember. I'm gonna get a 50,000-foot question because you're a consultant. I know what consultants do. They fly in and then they fly out, and what they leave behind may be good, may not be. I've used them in the past in my business. What is the most secure, reliable, not cost efficient, but most secure, reliable source of energy that power companies have as a choice to sustain power in peak load situations?
I think generally the most reliable power systems are those that have a diversity of resources. People use the analogy of it's like having a basketball team. You don't want, 5 point guards out there. You want, people who can play all the different positions, because the way I explain it is the utility system needs 3 different things: capacity, which is meaning the peak load. It also needs flexibility. So if you had a system that was, 100% nuclear units, that's not going to be reliable. Anytime the load changes, the lights are going to go out because nuclear units generally don't change their output at all. And you also need low cost energy. And so it's kind of this optimization of what portfolio of resources gives us the energy, the capacity, and the flexibility, capacity being megawatts, energy being megawatt hours at the lowest cost and in the most reliable way. And there's other reasons to have a diverse supply of resources. We've seen instances where a single fuel can have challenges that occur across the fleet. There have been notable instances where that was gas and there were supply interruptions on the gas system. We've had instances in the Southeast where cooling water was constrained due to drought and high heat, and that can affect a number of the the steam units that use cooling water. They can be derated or even taken offline by the that effect on the cooling water. And so having a diversity of resources also makes it more resilient to those challenges that can affect any one resource. So I want to answer your question, but I think the answer is it's an all of the above solution. If you had a power system that was 100% powered by anything, that is not going to be reliable.
Okay. So in your estimation, what reliable sources does Duke have to use, such as was mentioned on June 23rd when we had that huge demand for power? What resources would you have chosen to use? You use the term uneconomic, you use the term unreliable, you use the term not cost efficient. And you're certainly fully aware of in the Southeast and or across the U.S. where we are required to keep the lights on, and we're moving into an area where that can or cannot happen, depending upon the choices we make on reliability. I'm more not a all of the above approach. I'm more of the what works approach. And we get over 50% of our power from nuke. Why is that unreliable? Because of cooling water temperatures and those kind of things. We get 50% of our power from that. Why is that unreliable, as you just stated?
I'm sorry, I don't want to clarify. What I stated was that meeting 100% from any one resource would be unreliable.
Okay, I got it.
But yeah, so I mean, to your specific question so June 23rd, outside of the test period, so my analysis did not look at it, but generally on a high demand day like that, you're going to use everything. It is certainly an all of the above solution on days like that, where every resource you have you're going to try to run it. Nuclear, it does provide, as a very high availability and other things like that. So, I'm certainly not, I think it has an important role to play in my personal opinion, as an operating resource that's existing, and it has a high availability. So I think on days like that, you're going to use all of the above. The point I was making was simply that you do need a diversity. 100% nuclear system would simply just not work because the units are not flexible, and would also have a resilience concern that if you do have cooling water constraints across, your fleet, then you would be in challenging periods during some periods.
Based on your testimony, I just don't, I'm trying to understand, what you think that the decision of this commission should be, and that of Duke as well, or any other power supplier across the country. What do we do moving forward? I mean, what does 6 months of coal on the yard mean as far as reliability to you?
Well, coal units also have, susceptibilities to outages as any unit does. Coal piles can freeze. The cooling water issues I mentioned can affect coal units as well. These are also tend to be older units, and so their availability is often much lower than that of newer resources. So, I think it really is a diverse supply, a portfolio of resources, I think, is the answer. And you want to be doing that optimization through proceedings like the carbon plant IRP proceeding to kind of figure out what is that optimal portfolio of resources that gives you reliability, resilience, and lowest cost.
Okay. when I think you referred to Marcellus and Utica, freezing as well. And you kind of, factually shed some light on volatility of gas supply and pricing, in your testimony. Is that correct?
That's correct. I highlighted both the reliability concerns that we have periods where, in Winter Storm Elliott, Marcellus and Utica gas production was severely affected by well freeze-offs. During Winter Storm Uri, we saw the Permian and other, Texas basins had similar freeze-offs that then, in both instances, those events precipitated reliability issues. So I was focused on that reliability, but also the economic risks that, most gas is contracted on short-term basis and the price is volatile on a day-to-day basis, as well as over the long term, as we've increasingly, the domestic natural gas price in the United States is now increasingly tethered to the global price because of expanded liquefied natural gas exports. And so I think there is going to be those factors, I think, point to a both high and volatile price for gas going forward on a daily and interannual basis.
Going back to my comment about what works in Winter Storm Elliott, what part did you see solar and battery storage play in that scenario, that weather event?
So I didn't do the exact analysis, but batteries, if there were more batteries deployed, they would have been available and I think contributed during that event. Solar, I think, was producing some. Obviously, it's the dead of winter, so it's not the best output, but during the daylight hours, they are producing. And so I think solar and batteries work together to help meet that need. But I'm certainly not advocating that. Again, no one resource does everything, and 100% from one resource is not a reliable solution. So using transmission ties, using wind resources from this region and other regions, as well as the existing resources and, nuclear, hydro, all of these things, I think, again, that's your most reliable, resilient, and low-cost portfolio is going to have a diversity of resources that protects you against events like Winter Storm Elliott.
When you say more batteries, battery life's roughly what, 4 or 5 hours?
Yeah, most of them are built with a
Right.
4-hour duration. And so that's why I was, indicating that it would typically complement, it'd work with the solar production and the other resources and kind of get you through, in summer periods, the peak net load is, 3 or 4 hours in the late afternoon, early evening. And that's even getting shorter as we get more solar kind of meeting your late afternoon demand. In the winter, the peaks can be a bit longer, 5 or 6 hours. But you still, with a fleet of batteries, you can either dispatch them all at, if you have a 6-hour peak with 4-hour batteries, you can run them at 2/3 output for 6 hours, or you can just run, if you've got, a lot of batteries, you run some for 4 hours and then they run out of juice, and then you've got the other, your other batteries that are running. So if you really do have one of those 5 or 6 hour peak periods, which is fairly unusual, I think batteries can still significantly contribute. And certainly when they're working with other resources like solar, often the winter peak is in the morning. And so the battery is going to kind of get you through the, 4 or 5 a.m. until like 8 or 9 a.m. when the sun production is usually getting a lot higher. And so and that was why I was saying that batteries and solar often work together. But again, I'm not saying 100% solar and batteries. I think there's going to be a fleet of resources, and we already have that fleet.
Also, you alluded in your testimony about solar and wind. Given the political environment and the cancellation of wind contracts, those kind of things, how can you, Duke and us in making decisions, how can we do that? I mean, there virtually is going to be, as I see it, hardly any wind projects moving forward. The costs are somewhat prohibitive in Dominion's wind project. They'll probably have somewhere in the neighborhood of $11 billion, which equates to an AP 1000 that Duke has a permit for and could utilize in South Carolina, and or my assertion that we could use another plant at Sharon Harris. all of those things being equal, where does wind play into our decision-making process moving forward between now and 2030?
Yeah, so I think that's the timeline is exactly the issue is that, I think as it was, most of the wind resources the company was looking
Yep, that's right. Okay. Yeah. No. That's not. I've been teased about my name, but that's not a tease I've heard so far. I'm sure it's coming up at some point. Yeah. Yeah. So, can't predict what people will say or do. But, okay. Yeah. You got it. Yep. Yeah. Perfect.
Testing.
Yeah. Yeah.
Okay, let's go back on the record. We still do not have WebEx streaming ability. However, the court reporter, the microphones are working and the court reporter will be transcribing the hearing. At some point, our WebEx YouTube video may come back online, but we are not going to wait for that. We will proceed with the court reporter transcribing the hearing. With that, let's continue with questions from Commissioner Tucker.
Thank you, ma'am. Scoggin, just a couple more questions and I'll conclude. I was somewhat taken back by your assertions here about the decisions that Duke made in uneconomic dispatch with the coal plants in the situation we found ourselves in. And then you state that you respectfully recommend that the commission disallow the recovery of $15.7 million in net losses that occurred because of imprudent dispatch decisions on DEP's coal fleet. Day ahead, can't predict the temperatures and make a good guess at it. I mean, that seems like that statement is, Monday morning quarterbacking after the fact. And they took every diverse resource they had to eliminate a blackout. And sure, the coal plants are old. The coal plants were, I think in the Obama administration, I think Duke and every other utility thought that they were going to be shutting them down sooner. Did not anticipate the 4 to 5% annual growth rate. But those coal plants are essential now until we get something to replace them. So, I mean, help explain to me that statement and why you would assert that when you got 4-hour battery storage, you got dark days for solar, we got no opportunity for wind. The only place is in northeastern North Carolina, which is in the middle of a military bombing range. We're not going to do the offshore wind. We don't have that access available to us. I mean, I'm trying to get a sense of your background in 20 years with grid technologies, or 7, and 20 years in the industry as an expert and a consultant. Where do we go from here, and what are the pitfalls Duke made by doing the utmost job of keeping the lights on?
So yeah, a few points. And so the Monday morning quarterbacking is what we were trying to avoid, and that's why we did the day ahead price validation, where we looked at what information was reflected kind of in market prices the day ahead. At the time, the company would have been making decisions about which units to commit for the next day. And yes, there's always going to be error and uncertainty on that day ahead time scale. And so we're not attempting to penalize them for, not knowing what the weather is going to be tomorrow. Certainly, that's not our concern. And that's why we did that validation, to look at the information that was available at the time they made those decisions. With regards to the reliability, the periods we're looking at here where we recommended the decommitment of the coal units, these were not the super peak periods. As we just went through on this, the one example, the coal units did turn on as the peak demand was approaching. What we are talking about here, and this is why we use both system lambda and the day ahead prices, that price and that lambda reflects the value of that energy, and therefore it inherently moves with system demand. And so in these super high, any high demand period, the lambda and the price are going to be high. It's going to be higher than the cost of the coal unit, and the coal units are then going to properly run economically during those periods. The periods we are focused on in our analysis are not those peak periods. These are lighter load periods when there are abundance of other resources at a lower cost, as indicated by the system lambda being low, as indicated by the day ahead prices being low. And those are the periods we're looking at. So these are not periods where decommitting the coal units should have had any impact on reliability. There was an abundance of resources to meet demand. Demand was not that high generally. And that's why we use the lambda and the price, because that price number, that dollar per megawatt hour lambda or price, reflects the all-in supply and demand out there. And so in itself, it shows it's not a high demand period. Finally, I think the question I was in the middle of answering, and I think you alluded to it again about going forward, what do kind of some of the near-term regulatory challenges for wind mean for what you and the company should be doing? Yeah, I think that the timescale we've been talking about with certainly offshore wind was always in the 2030s to begin with. And I think the current administration will not be there on January 2029 under all, we don't know who the next president will be, but it will not be President Trump. And so I think some of the regulatory challenges that have been posed by the current administration will go away then, if not sooner. There are ongoing court challenges. A judge just recently allowed the Revolution Wind project off of Rhode Island to proceed. So it may be resolved sooner than that in the courts. The point being, I don't see these near-term, hopefully short-term regulatory issues as really having material impact on what resources might come on in 2035, which is what we're really thinking about with offshore wind. I'd also point out, in the closer term, there are existing as well as near-term planned land-based wind projects in other regions. The company could, by wheeling power through MISO or PJM, obtain some of that energy as well in the near term through, a power purchase agreement. So I think there are other options. And then, land-based wind development in North Carolina, I think is something that could be explored as well.
Okay, you're familiar with the outcome of the
What's that?
ARFI here, right?
Could you spell it out? I'm not sure I am.
I think I recall that was due in July. The bids came in July, and no one was chosen because of the cost of the bids.
Okay.
I think that would be a correct statement. Is that my information is correct? I'll
Okay.
get a nod from Duke. So I mean, wind is solar's a player, and no one here is objecting to solar. Of course, the private developers seem to have the tax incentives will be gone in 27. That's going to be a holdup as well. And then we're talking about the coal plants not being efficient. I get all that. I know that they haven't spent all the OEM on them that they probably should have, and a lot of them are shut down until they're needed or idling. So yeah, the ramp up, ramp down economic part of it. But I'm just trying to see for you to share with me, what else do we have? I mean, we've got 4 natural gas turbines coming on, CCs, CTs coming on. Would you recommend us building or having Duke build more LNG storage so that we can overcome the price spikes and the volatility of availability? I mean, you're here as a consultant, you're here for SACE. Tell me what I need to hear from you.
Sure. I mean, I think there's a lot of opportunity to add batteries that give you large capacity value for meeting resource adequacy and work with the existing solar. There's large complementarities between solar and batteries, as I was discussing a little bit ago. And I think given the large amount of solar the company has, they can add batteries and really use that to move the solar around to fully meet these shortened peak net load periods. I think transmission ties can also help in a number of ways. It gives you access to diverse resources in the neighbors around you. And I think that's helpful on a day-to-day basis. If there's cheaper power somewhere else, you can bring that in. If you've got a lot of solar or whatever at any point in time, you can export that. They can also be helpful during these super peak demand events to help keep the lights on, because large extreme weather events are not that large in their geographic spread. And given the number of neighbors that Duke and the other utilities here have, I think they can use those ties to access other resources that may be available elsewhere, either in PJM or elsewhere in the Southeast. So I think it's a mix of that. I'm going to, I think, be engaged in the carbon plan proceeding, and I think we'll probably continue this conversation there. But I think, the other point is that these new resources we're adding, the batteries, the solar, I think will work well with the existing fleet, and you add to that. We're not talking about tearing out the entire fleet. We have there's a lot of value, and I think many of these the nuclear plants and things like that.
Well, Duke continues based on legislation to try to acquire solar. The private developers, we're not hitting our goals based on the carbon plan with the private developers with solar. Tax incentives are going away in 27. The current administration seems to be trying to nix the wind opportunities that exist. And I'm just looking for answers, because there's a lot of pressure on us to keep the lights on. And I mean, I'm just trying to understand from your expertise what our choices would be. And, based on today's circumstances, I'm not hearing a great deal. What do you think about the LNG storage?
I honestly don't have an opinion on that.
You wouldn't, because you could supply natural gas when maybe Transco is shut down or Marcellus is frozen or whatever. You could bring up 3 to 4 days worth of availability of natural gas and insert it into our North Carolina pipelines to keep the power on.
I think
that's not a viable option, and you don't think that is, or couldn't speak to that?
I certainly think that there are challenges with pipeline gas today. We've seen them, Winter Storm Elliott and other events. I'm not a gas system expert. I'm not going to attempt to weigh in on solutions to that. I think from the electric sector, I'd say that diversifying the resource mix is the best solution. Having a diverse portfolio of resources makes you less exposed to any one of those resources having outages. And transmission also gives you that more diverse portfolio of resources.
Okay, very well, sir. Thank you for being here today. Thank you for your expertise. Always enjoy hearing what you have to say. May not agree, but enjoy that. That concludes my questions. Thank you, Commissioner Kimwright.
And Mr. Goggin, I think there's going to be some questions from Chairman Brawley and Commissioner Vanderbart. I'm going to just give the parties a little bit of instruction. We will have questions on commissioners' questions. However, we've gone a little bit into carbon plan proceeding, and so I will give some questions that we've gone beyond issues in the rider proceeding. Although I think it was some of the questions were directly related to Mr. Goggins' testimony. I will allow some leeway, but when we do have questions on commissioners' questions, I am going to ask the attorneys to really focus on not carbon plan proceedings. It's outside of this proceeding, but only what is specifically addressed in this rider proceeding. And with that, Chairman Brawley.
Thank you, Commissioner. And is it Dr. Goggin?
Mr. Goggin.
Okay. I want to address you correctly, sir. I kind of want to loop back to two things that were said earlier. And some of this was the discussion of the July 1 through 5 in 2024. And part of your comment on some of the use of coal that should not have been justified was based on the idea of your assumption that it would be that you could ramp those coal plants up in a day or less. And I had received a knowledge which I wanted to confirm that most of the Duke plants take at least 2 days to ramp and sometimes longer. So that part of the reason that they were up on the 2nd and the 3rd was anticipation of the 5th, knowing that if they waited till the 4th, they would not be able to supply sufficient power on the 5th. Without you committing that that is in fact correct, if it is correct, would that change, or what impact would that have on whether or not it was justified for Duke to be running those plants?
So our counterfactual fully accounted for the startup times that the company provided, and it's confidential information, so I want to be careful, but it's on the bottom of page 16 of my testimony. We discuss how the exact times that the company indicated for its units on the bottom of page 16, and it's fully accounted for in our analysis, and I believe consistent with those units being able to start in time for events like that. And you can look at the exact numbers. I just don't want to.
I'll go back and look at it again, sir, and thank you for that. The second was you made reference to putting in purchase power agreements. One of the things that I learned early here, the first big thing I worked on was Winter Storm Elliott. And at that time, Duke had a firm contract with PG for 1 gigawatt, which was curtailed during that time. And I wondered if it's not counterintuitive to rely on power purchase agreements with other balancing authorities, which are most likely to be curtailed when you most need them.
So it's certainly it could be a risk during very high demand periods. Again, I think that what we're looking at here, however, are generally light load periods. As I walked through a few minutes ago, the periods where these coal plants were running and our analysis shows they should not have been. That was because the coal unit's cost is higher than system lambda and higher than the market price. And that lambda and the market price fully reflects that supply and demand. And the fact that those prices are low shows that this was not a super high demand period. And because of that, I think we can have confidence that these transactions, the firm transmission transactions with another balancing authority would not be curtailed. That curtailment is typically a very rare event. It happened during Winter Storm Elliott, but it's not something that typically happens. And I think would be extremely unusual if not nearly impossible for it to happen during a low demand period like we're talking about here, just because there are plenty of resources everywhere during these low demand periods that we're talking about in this case.
So your discussion of system lambda and the low price is the days leading up to the high demand days.
That's correct. Those are the periods when our analysis was decommitting the coal units. And those are periods by reflected in the lambda and the price when it would be, I think not a credible threat that there would be a curtailment of a transmission tie just because the demand is not that high.
Okay. It seems to me maybe there's some optimistic assumptions there, and being cynical, I've already told the chair today, don't make optimistic assumptions on how long these are going to take, because as soon as you say it's going to be short, it turns into long. Thank you, sir. I think there's some, I believe I understand your point of view and the way you're interpreting the facts, and I appreciate your patience with us.
All right, thank you.
I'll try to be brief. Most of these questions have been good. I guess my only bit that I'm concerned about is, and it's very difficult for you to come in here. I get it. I mean, people are going to think it's hindsight. You got hindsight in your favor. But I'm trying to put myself in Dig's position during this period, and I saw where are you not assuming that if they had gambled wrong and let's say, I mean, I know now we can look back and say what we said, but because we have a fairly significant solar penetration here, and it seems to me that puts a higher risk on dispatchable power, so that it also causes, the way I understand your system lambda during middays, I mean, that the incremental price in North Carolina is really low, right? When our solar fleet is humming, but at the end of the day, that means your reserve, well, you can call it lots of different things, but your dispatchable power could end up being extremely expensive. And I think this is what gets to Commissioner Brawley's point. I mean, is your analysis not assuming that there's an infinite supply of constant price external power that they could have tapped into? Am I missing that?
Sure. So yeah, I'll start with the beginning. So on the solar, again, we don't want to be doing Monday morning quarterbacking, and that's why we did the validation with the PJM day ahead price, that's based on the forecast as known for both load and solar output in that day ahead time frame when the commitment decisions were being made on the coal unit. So we're not trying to, if the solar comes in lower or higher, we're certainly not trying to judge the company for that inherent uncertainty. And that's why we did the day ahead validation, to say, based on the information that was known day ahead, did they make the right call? And periods we've identified.
But you'd admit that even then you don't know the answer for sure, right? The day ahead. I mean, if you're sitting in their seats and you're looking at your day ahead, because we have a large solar component, we could have had a cloudy day the next day, and that would have changed the calculus somewhat.
And so I think that's a good transition to the second point I was going to make, is that these periods where we've decommitted the coal units that the company in their analysis, or in reality ran in our analysis, we have decommitted them. Again, these are not the super peak periods. These are periods where system price is low, lambda is low, and so you have some wiggle room in the system, and that includes the availability of resources to be that alternative source of supply. If you did what we were proposing and turn the coal units off, there are a lot of resources available. And
sorry, you were including reserves as well, right? Because I mean, one of the units could flip out, and now all of a sudden you're okay.
Yes, so operating reserves certainly for that as well. And basically the way there's a supply curve, and it's helpful to kind of have this image in your head. There's a supply curve of resources, increasing cost or price of providing energy as you kind of move up that supply curve. And in these periods that we're talking about in this case, these relatively low demand periods where the coal units could have been turned off and where the lambda and the price is low, you're on the left side of the curve. The curve is The price is low. It's also very flat over there. There's gigawatts and gigawatts on their system, on neighboring systems, where pulling up additional amount of energy from another resource, you're going to move along that curve, but it's so flat over on that left side of the curve that you can bring in those resources.
Is it during this period when it got so hot? You think you're pretty confident with that? Or maybe, you may be right. It's just when, there's a risk here. There's a sort of I don't know if if things got bad, they get bad really quickly. So it's kind of a precautionary principle type approach, how much, it's not just a 50-50 type of a gamble. They ran the units a little bit longer to the tune of 15 million, but if things had really gone sideways, 15 million would have been a great deal. Is the question that they're having to struggle with. Anyway.
Yeah, and I certainly understand the point, and we're certainly, keeping the lights on is by far the most important thing here, and we understand that. And I think none of the periods we're talking about, I think we would have, I don't think any of these decommitments would have opened up reliability concerns. That's certainly not the intent. And, certainly the big number over the course of this year, we can focus on individual hour here and there, but the big story is over many days, many hours, a large share of the year, there was uneconomic coal generation going on. And so, maybe we can quibble out 1 hour here or there, but I think the big story remains.
Okay, thank you. And just for clarity of the record, I will point out that in the 2022 carbon plan proceeding, and this may address some questions that might be asked, the commission made a legal determination that Duke Energy was not permitted to obtain onshore wind through a purchase power agreement. That legal determination was made in the initial carbon plan proceeding. With that, we will move to questions on commission questions. And as I mentioned, please identify the commissioner that asked the question with a brief summary of what the question is. And again, let's focus on issues that are specifically relevant to the fuel proceeding as opposed to the upcoming carbon plan proceeding, beginning with Duke.
No questions. Thank you.
Justin Simolovsky with NCSCA. Just one clarifying question, Mr. Goggins. Commissioner Tucker talked about the requirement to keep the lights on, and Commissioner Vandervaart reiterated that question himself. But the analysis that you did is not a reliability analysis. It is more of an economic impact to ratepayer analysis. You're looking at what could have been more beneficial to ratepayers to achieve the same results. You're not trying to change results or outcome. You're just looking at the financial impacts. Is that a correct characterization?
Yes, I think so. This is an economic analysis, and looking at the hours and everything that we've identified, I don't think it would have any negative impact on reliability.
And just to clarify once more, that you only looked at existing facilities that were available during that same period of time, not worrying about future and trying to substitute technologies, just what was available that could have delivered at that moment.
That's correct. It was the existing fleet. Yes.
Thank you.
I have a couple. So I think this was Commissioner Tucker's question with regards to DEP and some of the implications of your analysis, given instances that you identified there being uneconomic dispatch around June 23rd, so presumably a hot period. What is your familiarity with the ERCOT system and their, integration with batteries and solar over the past 2 years or so?
Presiding Commissioner, June 23rd was not part of the test period in this proceeding, and ERCOT is not remotely relevant to the fuel cost DEP incurred in the case at issue here.
Okay.
Brief responsive.
Please provide a response.
So I believe it's relevant with regards to, I think, one of the questions that I think DEP has raised during cross-examination, explicitly and implicitly, which is with regards to replacement resources given what would happen if coal units were decommitted. And so really the question is sort of going to the ability of other resources, as you have mentioned, basically a portfolio can sort of provide energy and other resources to the system. So really that question is kind of going to that point.
Okay, so let's, can you identify the commissioner and the commission question as opposed to the cross-examination question? Because we need to keep it specifically related to questions on commission questions.
And I'll reiterate again, this is Commissioner Tucker's question with regards to what should DEP have done during hot periods, basically. And my response was just sort of going to why that was relevant. And I was sort of referencing some of what was discussed both during commissioner questions and also cross-examination. But that's the ultimate commissioner question that I was going to.
I'm going to give you a little bit of leeway. I think we're going very far astray of this fuel proceeding, but I will allow you to ask the question and then to receive an answer. And then, then let's move on from that question, because I believe this is well beyond the scope of this fuel proceeding.
Thank you.
Yeah, so I think the ERCOT system has used solar and batteries, and yeah, I think the ERCOT, the Duke system has a larger amount of solar. It is moving in that direction of having a lot of batteries, and those resources have been available and have been used to meet the peak demand there. They've had record peaks for the last several years, and those new resources have been filling in and meeting that and keeping prices low. So I think there is a large opportunity to use solar and batteries to meet demand in these periods.
Thank you. And this is with regards to Commissioner Vandervaart's question, essentially, and I'm paraphrasing, this is not a direct quote, but just the concern that basically we are assuming infinite generation to replace uneconomically dispatched coal units. My question is, and I think I can ask this in a way that will not elicit any confidential information being disclosed, but would it be fair to say that most of the instances in which you found uneconomic dispatch, there were at least a few units that were still up and running?
That's correct.
Yeah, and please, let's not go into any confidential information with your answer.
Yes, as a general matter, there was significant headroom of other resources that were not on at all, or on and running at low levels of output where they could have increased their output if needed as an alternative. And again, I think that's as to be expected in these periods that we're looking at, and it's reflected in the low system lambda and the low market prices. The fact that there is, demand is low and supply is high at these times.
No further questions.
With that, we've come, excuse me, public staff.
No questions from the public staff.
Okay, thank you. So we've come to the end of questions on commission questions. So Sace, I will hear a motion in regard to admission of the 2 exhibits attached to Mr. Goggins' testimony.
Thank you, Presiding Commissioner Kimmerite. At this time, Sace et al. Would seek to move into the evidence. I believe these are exhibits MG1, MG2 that were attached to Michael Goggins' pre-file direct testimony as if given from the stand again.
Seeing no objection, the 2 exhibits attached to the direct testimony of Sace witness Goggin are admitted into the record. And with that, I think we've come to the conclusion of your testimony. Thank you for being here. You may step down and be excused.
Great, thank you for having me.
And we will now move to the public staff.
Thank you, Presiding Commissioner Kimwright. The public staff witnesses were excused by order of the commission, but the order asked that we move their testimony into the record at this proceeding, so I'd like to do that now.
Please proceed.
Thank you. On September 2nd, 2025, and docket number E2 sub 1358, the public staff filed the testimony of Evan D. Lawrence, which consisted of 16 pages of testimony, 1 appendix, and 2 exhibits. The testimony contained confidential information, and so the public staff also filed a redacted version for the public. On September 25th, 2025, the public staff filed in that docket an errata sheet correcting an error and therefore refiled all the exhibits. On September 25th, 2025, in docket number E2 sub 1358A, the public staff filed a 1-page summary of the testimony of Evan D. Lawrence. And at this time, I would respectfully ask and move that the pre-filed direct testimony of public staff witness Evan D. Lawrence, including Appendix A, and also his pre-filed summary, be entered into evidence and copied into the record as if given orally from the stand.
Seeing no objection, the direct testimony of Evan Lawrence that contains confidential provisions consisting of 16 pages and 1 exhibit, as corrected on September 25, 2025, will be entered into the record as if given orally from the stand. The summary of his testimony filed on September 25, 2025 will also be entered into the record as if given orally from the stand.
I believe there might have been 2 exhibits for Mr. Lawrence.
Right.
Just so I don't get nervous tonight, there'll be 2 exhibits, one as corrected, they'll be marked in the same manner and then moved into the evidence in the record with the markings as they were when they were pre-filed.
Okay. Seeing no objection, the 2 exhibits attached to the direct testimony of Evan Lawrence will be entered into the record.
Thank you. Final witnesses were a panel on September 2nd, 2025, and docket number E2 sub 1358. The public staff filed the joint testimony of Heymuth Mehta and Vivian Fang, which consisted of 18 pages, 2 appendices, and 2 exhibits on September 25th, 2025, in docket number E2 sub 1358A. The public staff filed a 1-page summary of the joint testimony of Heymuth Mehta and Vivian Fang. At this time, I would respectfully ask and move that the pre-filed joint direct testimony of public staff witnesses Mehta and Fang, including appendices A and B, and also their pre-filed summary, and also their, I ask that those be moved. I ask that the testimony and summary be moved into evidence and copied into the record as if given orally from the stand. And I would further respectfully ask and move that the 2 exhibits attached to their pre-filed direct testimony be marked in the same manner as they were when they were filed, and those also be entered into evidence and copied into the record as if given orally from the stand.
Okay. Seeing no objection, the joint direct testimony of public staff witnesses Mehta and Fang, consisting of 18 pages and 2 appendices, filed on September 2, 2025, along with a summary of their direct testimony filed on September 25, 2025, will be entered into the record as if given orally from the stand. The 2 exhibits attached to the joint direct testimony will also be entered into the record.
Thank you.
Okay. And I think that is the conclusion of the public staff's case. Is that correct?
Yes, it is. Thank you.
Okay. So with that, we will move to Duke's rebuttal case.
Thank you. The company calls the operations panel of Mr. Flanagan, Mr. Suez, and Mr. Lloyd.
Good afternoon, gentlemen. If you can place your left hand on the Bible and raise your right hands. And do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you. Gentlemen, you were in the room earlier, so confirming that you heard that the pre-filed direct testimony has already been entered in the record at this point.
Yes, that's correct.
Great. And so just logistically, we're going to walk through introductions with each of you, and then we'll introduce your rebuttal testimony and your summary of your rebuttal testimony. So, Mr. Suez, I would like to start with you, please, sir. Would you please state your full name and business address for the record?
Yes, my name is John D. Suez. My business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
Thank you. And by whom are you employed in what capacity?
I'm employed as Managing Director, Trading and Dispatch by Duke Energy Carolinas.
Thank you. And could you please briefly describe your role and responsibilities at the company?
Yes, in that capacity, I lead the organization responsible for power trading on behalf of Duke Energy's regulated utilities, including Duke Energy Progress, LLC, DEP, and DEC, collectively the companies, as well as generation dispatch on behalf of Duke Energy's regulated utilities in Indiana, Ohio, and Kentucky.
Thank you,
And
sir.
Mr. Brushwood, before we continue, do you have name placards for the witnesses for the benefit of the court reporter?
Thank you very much. Thank you, Ms. Toon. Turning to you, Mr. Flanagan, would you please state your full name and business address for the record?
Yes, my name is Jeffrey Flanagan. My business address is 8320 East Highway 150 in Terrell, North Carolina.
Thank you. And by whom are you employed in what capacity?
I'm employed at Duke Energy Business Services, DEBS. DEBS is a service company subsidiary of Duke Energy Corporation that provides services to Duke Energy and its subsidiaries, including Duke Energy Progress, LLC, DEP or the company, and Duke Energy Carolinas, LLC, DEC.
Great, thank you. And would you please briefly describe your role and responsibilities at Duke Energy?
I'm the General Manager 3 of Carolinas Dispatchable Generation West. It includes Marshall Steam Station, Asheville, W.S. Lee Combined Cycles, and the CTs at Asheville, W.S. Lee, Lincoln, and Mill Creek stations.
Thank you, sir. Turning to you, Mr. Lloyd, would you please state your full name and business address for the record?
My name is Cedric Lloyd. Business address is 4201 Auburn Church Road, Garner, North Carolina, 27529.
And by whom are you employed in what capacity?
I am employed by Duke Energy Progress as the General Manager of System Operations.
Thank you. And please describe your responsibilities in that role at Duke Energy.
I lead the team that's responsible for system operations engineering, control room operations, and transmission outage coordination. We're responsible for the balancing authority and the transmission operations for Duke Energy Progress.
Thank you. Returning to you, Mr. Suez, I'm going to now introduce your testimony. Did you cause to be pre-filed in this docket joint rebuttal testimony along with Mr. Flanagan and Mr. Lloyd, consisting of 37 pages and 2 exhibits?
Yes.
And confirming that the company filed corrected rebuttal testimony on September 26th that has been submitted to the record with the commission.
That's correct.
Thank you. And if I were to ask you those same questions today that appeared in your pre-filed joint rebuttal testimony as corrected, would your answers be the same?
Yes, they would.
And your joint rebuttal testimony does not include any confidential information?
That's correct.
Thank you. And the company pre-filed a summary of your joint rebuttal testimony with the commission?
Yes.
Thank you. And Presiding Commissioner, at this time, I'd ask that the joint rebuttal testimony of Mr. Suez, Mr. Lloyd, and Mr. Flanagan, as pre-filed, be entered in the record as given orally from the stand, along with their pre-filed summary also be entered into the record as given orally from the stand, and their 2 exhibits pre-marked as identified.
Seeing no objection, the joint rebuttal testimony of DEP witnesses Suez, Flanagan, and Lloyd, consisting of 37 pages filed on September 16, 2025, as corrected, will be entered into the record as if given orally from the stand. The 2 exhibits attached to the joint rebuttal testimony will be identified as pre-marked, and the summary of the testimony will also be entered into the record as if given orally from the stand.
Thank you. This panel.
And Mr. Brushworth, Chairman Brawley has just indicated that the joint rebuttal testimony may be marked as confidential. Can you confirm whether there are or are not confidential provisions in the joint rebuttal testimony?
Presiding Chair, Presiding Commissioner Kemmerer, I can help out. There is some confidential response, then direct response to confidential information that witness Lynn cited. I believe it is page 34.
Thank you. That I'm looking at it here as well. Appears on page 31 as well as 34. It does appear there's confidential information. So with that, I'd amend the statement and ask that the information pre-marked as confidential be entered in the record as pre-marked and maintained under seal.
Okay. Seeing no objection, we will allow the joint rebuttal testimony with the confidential provisions to be entered into the record as if given orally from the stand.
Thank you. The panel is now available for cross-examination and questions from the commission.
And I note that both NCSEA and SACE have reserved time for cross-examination. It's my understanding from both NCSEA and SACE that some of their questions may elicit confidential information. So when that occurs, we will go into confidential session. The YouTube video will be ceased, and anyone in the room who has not signed a non-disclosure agreement with DEP will have to leave the room. Also, Duke, please ensure that we do not start entering into any type of confidential information before the room is, the people who have not signed the NDA have left the room. So with that, let's begin with cross-examination from NCSEA.
Thank you, Presiding Commissioner Kemmerer. Good morning. Good afternoon. Thank you all for being here. I'm just going to jump right in. If you could go to page 28 of your joint testimony, please. It looks Starting on line 20, it says, reading witness Lynn's testimony, it appears that he is using this fuel proceeding to again raise topics of interest to NCSCA, which clearly fall outside the framework of this proceeding. Is that correct?
That's correct.
And to the best of your knowledge, isn't part of the statutory framework, and I'm quoting the statute 62-133.2, for the purposes of the annual hearing, each public utility shall submit to the commission verified annual information and data for the historic 12-month test period, and that includes, listed among other things, generation mix by types of fuel used.
I don't have the statute in front of me, but that sounds appropriate.
Okay, subject to check.
Subject to check, yes.
And your testimony saying you've read witness Lynn's testimony, you are therefore aware that on pages 7 through 11 of his testimony, that he does provide comments on the generation mix in both the terms of megawatt hours and total costs.
Can I refer to Mr. Lynn's testimony?
Yes. Do you have a copy in front of you?
I believe I do. So you said pages 7 through 11?
Yep. And page 10 might be the most succinct way to do this. There's Lynn table 2, which breaks it down.
Okay, I'm on page 10. Lynn table 2 appears to show a percentage of generation percent compared to total fuel costs without purchase power for different categories.
So that's Mr. Lynn commenting on the generation resource by mix, correct?
That's correct.
So, and you're aware that Mr. Lynn was able to, Mr. Lynn expressed concerns about the concentration of the company's generation mix, particularly with natural gas in both terms of generation and total costs.
Yes, and I believe those were the comments I was making. It seems like it was kind of alluding to other hearings, not necessarily fuel hearing.
But doesn't the statutory framework allow commentary on discussion of generation mix by types, or is it the company's position that they're only required to provide this information and then no intervener or their experts can comment on such a required information?
Objection. Calls to ask the witness to opine on the meaning of the statute, calls for a legal conclusion from a non-attorney expert.
Would you like to respond?
I'll try to rephrase.
Thank you.
And I think we can stipulate that witness Lynn's testimony is now in the record and is before the commission to be considered. So it's not material of whether the company thought it was relevant or not to present this analysis. It's now in the record for the commission to consider. We can move on if that.
I'll be happy to move on. I would just like to acknowledge that throughout the testimony, there's multiple attempts from both panels to discredit witness Lynn as being outside the framework. So all I am trying to establish is there are statutory language that enables such commentary and testimony from witness Lynn that is relevant to this commission hearing.
Okay. Considering that the testimony has been entered in the record, I will allow you to ask the question, but let's ask the question briefly and then move on.
Well, with that stipulation, I think I can move on. So thank you. And thank you, counsel, for clearing that up and making this expeditious. With that, can we then please move to page 31 of your rebuttal testimony?
Or there.
Starting on line 19, it reads, as natural gas continues to become a larger component of the customer fuel bill, DEP will continue to evaluate options to provide customers with a greater degree of fuel cost stability and to assure the natural gas financial hedging program continues to provide price risk and volatility mitigation as the company's gas exposure continues to evolve. Correct?
That's correct.
Do you see any distinctions between having to evaluate options with witness Lynn's recommendation to further study and investigate the impacts of fuel and natural gas as it increases in its generation mix?
Well, as stated in my rebuttal testimony, the hedging program is not fixed in time or fixed in scope. It has changed and evolved over time, and the company will continue to evaluate the hedging program over time as it has done historically.
So this comment is talking about the company will continue to evaluate just hedging as a solution and not other solutions or other options.
Yes, I believe this comment, since it's under the question that talks about financial hedging program, is specific to hedging.
Okay. Thank you for that clarification. And can we now move to page 33? And I'm going to be looking at that figure that was produced, the line chart.
Think we're there?
Okay, and this table illustrates the difference between DEP's weighted average natural gas hedge prices versus natural gas NYMEX settlement price over series months, correct?
That's correct.
And for clarity, NYMEX and the Henry Hub can be used interchangeably. That is.
It is a NYMEX Henry Hub
Yeah,
contract.
great.
Yes.
Thank you. And so just to break down this chart a little bit, we can look at the, I'm going to choose specific months. And I'm going to be fair in doing that. I'm not trying to be picking in a nefarious way. But can we look at the DEP secured price for July 2022 in that line chart? There, would you agree that it looks like for the NYMEX settlement price, it was somewhere around 675 MMBTUs, but the company was able to secure a price of an average of $3 an MBTU through their hedging practices, correct?
Yeah, this isn't the actual total price of gas paid. Of course, this is just the hedge.
Yes, the average settlement price that.
So the hedge price paid during that time period was $3, and I agree the NYMEX settle was approximately $6.75.
Great, thank you. And then just to move ahead into the test period, we also look at July 24. There, the settlement price for NYMEX was approximately $2 low, but the hedging was $3.75 an MMBTU, correct? From the company's hedge.
Yeah, I'd say like $2.50 for the NYMEX price, and the hedge price, yeah, I would agree, $3.75.
Right, and it's tough to predict this stuff, right? We're looking for ahead, and you're trying to secure certain prices, but we're not able to guarantee certainty. It's just trying to protect a portion of the fuel costs, correct?
Yeah, it locks in a portion of the fuel cost at that price.
Okay, and then just to clarify, and I think you got at this a little bit already, this is just looking at the average prices of the NYMEX and the company's settlement price for hedging during that period. But this table does not show volumes of fuel procured and how it affected the company's bottom line.
That's correct. It just
Okay.
says price only. There is no volume in this chart.
Okay. Presiding Commissioner Kemmerite, I think this is where the confidential session kicks in.
And is this confidential? Which NDA? Is it an NDA with NCSEA or is it an NDA with Duke that we need to be concerned with a confidential provision?
So NCSEA has a global confidential agreement with both DEP and DEC. So I guess if it's parties that signed an NDA with DEP for this proceeding.
So it's DEP's confidential information, I think, is what you're trying to elicit.
Yeah. Is it whose confidential information?
It's
Are we
DEP's.
DEP's? Okay. So, so we're going to end the YouTube video, and everyone that is present in the room that has not signed an NDA with DEP will need to leave the room during the confidential proceeding. And with that, we'll end the YouTube video. We'll go off the And so we will now move to questions from SACE.
Thank you, presiding. Oh,
So I think we are going to we were going to take a break, but let's just go ahead and take our lunch break. So we will have hopefully all these technical difficulties resolved during our lunch break, and we will go off the record and come back at 1:40. Thank you. I think we left off with SACE beginning cross-examination. Is that correct?
Just about to, yeah. So I'm ready whenever the commission is.
Okay, please proceed.
All right. Good afternoon, Menashe Magaru on behalf of SACE et al. My questions are for the panel as a whole. So whoever on the panel feels best placed to respond, feel free to do so. And as a flag, I know the commission's aware of this, but my questions concerning confidential information will be towards the middle of my cross-examination. I'll let the commission know when I'm about to get in there. All right. Can I have you, do you have your rebuttal testimony in front of you?
We do.
All right. Can I have you turn to page 10 of your rebuttal testimony, starting at line 5, and just let me know when you're there.
We're there.
Great. And here is where you reference testimony from a Sierra Club witness in the sub 1214 Duke Energy Carolinas rate case. Is that right?
That's correct.
Okay. And in preparing your rebuttal testimony, did you have a chance to review the commission's final order in that rate case?
No, I did not.
Okay. What I'm going to do then, in light of that, is Presiding Commissioner Camright, at this time, I'd request that the commission take judicial notice of that order in that sub 1214 rate case. The caption is "Order accepting stipulations, granting partial rate increase, and requiring customer notice." This is docket numbers E7 sub 1214, sub 1213, and sub 1187. Order was issued March 31st, 2021.
The commission will take judicial notice.
All right. And I'll ask the same question with regards to so did you have the chance in reviewing your testimony? And this is a little further down on that same page. Do you have the opportunity to review the final rate case order in that sub 1272 DEP fuel rider proceeding?
Is that line 20 you're referring to?
Yeah, around there.
I did not review that.
Okay. Similarly, Presiding Commissioner McKissick, I'd also request that the commission take judicial notice of its order approving fuel charge adjustment. This is docket number E2 sub 1272, and that order was issued November 18th, 2021.
The commission will take judicial notice of the order.
All right, great, thanks. Let's move on. So beginning on page 8, line 17 of your rebuttal testimony, just let me know when you're there.
We're there.
All right. So here you begin discussing some of your concerns with our use of System Lambda to identify instances of uneconomic dispatch. Is that right?
That's correct.
All right. I'm going to ask you to skip ahead. Sorry about this. So if you skip ahead to page 9, lines 5 through 6, and just let me know when you're there.
I'm there.
So I'm quoting here. You state, in other words, System Lambda is the appropriate price signal for dispatch decisions. And then you go on to note some concerns with its fit for backward-looking analysis. Do you see that?
That's correct.
Okay. Again, sorry for jumping around a little bit here. So if you go to page 11 of your testimony, this is lines 22 through 24, and just let me know when you're there.
I think we're there.
Okay. So the company uses GenTrader as its production cost model for unit commitment. Is that right?
That's correct.
Okay. Continuing to page 12 of your rebuttal testimony, you go into some depth. I'm not going to give line numbers. It's a fair amount, but you'll see towards the middle of that page, you go into depth about the specific inputs to GenTrader.
That's correct.
All right. I believe I've put the SACE et al. Exhibit notebook in front of y'all. Could one of you turn to, this is SACE et al. Potential cross exhibit 20, and this is a public exhibit.
We're there.
Okay, and so this is a discovery response from DEP to a discovery request that SACE et al. Sent. Is that right?
That's correct.
Okay. Presiding Commissioner McKissick, at this time, I'd request that this exhibit be marked for identifications. I'm sorry, I just blanked. Today is today. Presiding Commissioner Camright, I would request that this exhibit be marked for identification purposes as SACE et al. Cross. I think I heard council refer to them as the operations panel. So SACE et al. Cross operation panel rebuttal exhibit 1.
So we will, we will refer to this as SACE et al. Duke Operations Panel,
Okay.
Cross-Examination Exhibit Number 1.
So that's, if you don't mind me asking, so Duke Operations Panel cross rebuttal?
Cross Rebuttal Exhibit 1.
Okay, thanks. Just want to make sure going forward I use the right one, or yeah, right naming convention. If you could just take some time to review discovery request. This is from us, 4.61, and the response, and just let me know when you're done.
We're good.
All right. So would it be fair to say that in response to our request, DEP refused to provide these GenTrader inputs and outputs, at least in part because it deems them proprietary and commercially sensitive?
Yeah, that's correct. But also at the last part of 4.6.1, I did not go and look through the SACE request 1.9 and 1.3.4. So I'm not sure what was included there. But I agree with your statement about the first half of this of the statement.
Okay. Would it be fair to say that without these inputs, it would be challenging for any party to recreate DEP's unit commitment and dispatch process step by step?
Well, you'd have to have a copy of the software as well. But with a copy of the software and with all the data, I think that's what it would take, the software and the data.
So given this, any party seeking to assess whether DEP's unit commitment and dispatch decision-making process was in fact reasonable, they would probably need to just rely on whatever other best information is available.
I think to do the analysis, you'd have to run GenTrader backward looking a bunch of times, like I'm not sure 365 times or something like that. You'd have to go back in time and keep rerunning the unit commitment software to try to assess what you're trying to do.
But leaving aside the software issue that you flagged, we would not have been able to have access to your inputs or outputs.
I agree, yes.
Okay. Presiding Commissioner Camerite, at this time I have questions concerning confidential information and request permission to enter a confidential session.
So we will move into confidential session. Mr. McCoy, if you can end the YouTube
So again, just a couple remaining questions. Can I have you turn to, this is your rebuttal testimony. Page 23, lines 6 through 8. I'll give you some time to get there.
I'm there.
All right. Would it be fair to say that not all reliability factors are incorporated into GenTrader?
That's fair to say.
Okay. One last exhibit, I promise. Can I have you turn to SACE et al. Potential cross exhibit 8?
We're there.
This is a copy. Sorry, this is a copy of 62-133.2. I guess I refer to this fuel rider statute.
I see that.
Okay. Obviously, this is a statute, but I guess for purposes of the record, Presiding Commissioner Camerite, I request that this exhibit be marked for identification purposes as SACE et al. Sorry, got the, yeah. Duke Operations Panel Cross Rebuttal Exhibit 8.
It will be so marked.
Okay. Can I have you turn to, yeah. Can I have you turn to subsection D on page 3 of this exhibit?
We're there.
Can I have you go towards the middle of subsection D on this page to the sentence that starts with burden of proof?
We're good.
Right. Not asking you to give a legal opinion, but the language there, just as a paraphrase, provides that the burden of proof as to whether the cost of fuel and fuel-related costs were reasonably and prudently incurred, that burden of proof shall be on the utility, here DEP. Is that a fair paraphrase?
I believe so.
Okay. No further questions.
Thank you. So we'll move to redirect from Duke.
Thank you. Gentlemen, let's start with a few questions you got from NCSEA's counsel earlier related to the company's hedging program. I think these would primarily be for you, Mr. Suez. So you may recall Mr. Smolovsky pointed you to your figure 1 on page 33 of your rebuttal testimony.
That's correct.
And was comparing the cost of the hedging instruments the companies had procured relative to the cost of gas in the marketplace over time.
That's correct.
And so can you just take a minute and explain to the commission how DEP's hedging program provides value and risk mitigation to customers as part of the company's overall fuel procurement strategy?
Sure. The DEP hedging, natural gas hedging program is designed to ultimately reduce price volatility for customers. So it reduces swings up and down. And we use a methodical, structured approach within our risk guidelines that allows us to basically dollar cost average, like in the investing world. And so by buying smaller amounts of gas over time, up to 5 years into the future, we are essentially locking in that price of gas. And then if gas prices go higher, our customers financially, it has nothing to do with the supply of gas, the physical molecules. We're talking about the price our customers pay. The price is locked in at that price in which we hedged at. And likewise, if prices go lower, your hedges are, the hedged portion you have is locked in at that price. But with lower gas prices, now you enjoy lower costs for the remainder of your gas. So basically it allows us to enjoy or provide stability for our customers from gas prices going higher, but also allows them to benefit in what happens if gas prices go lower.
Thank you. And Mr. Smolowski also had a few questions for you about the relative percentage of gas that was hedged over time. And I understand those numbers are confidential, so we don't need to get into the specifics. But his recommended disallowance of the company's hedging costs in the test period did not correlate to the percentages that you discussed with Mr. Smolowski. Is that accurate?
No, they did not correlate. I couldn't figure out any correlation.
Okay, and so he essentially recommended what he called a de minimis disallowance of the company's hedging costs, which was in the millions of dollars. Is that fair?
I believe it was around 5 million, if I remember correctly.
Okay, and based on your testimony and your analysis of his testimony, is there any basis to disallow any of the company's hedging costs as imprudently incurred or unreasonable?
No, I believe we followed our hedging.
Objection. He's asking this witness to interpret statute of what is legal and prudent. I think that's something we should brief.
Mr. Brayshaw, do you want to respond?
Sure, I think he can give his general understanding of what the term reasonable and prudent means and have an opinion of whether the hedging costs that he's specifically responsible for incurring on behalf of the company and on behalf of customers were unreasonable or imprudent in any way.
Okay. Objection overruled. You may answer the question.
So I believe the company followed its hedging program within the risk guidance as designed. The net program provided the benefits for the customer as designed.
Thank you. All right, I want to turn to a few questions from counsel for SACE. So he asked a number of questions across a number of exhibits, and I don't have the exhibit number specifically, but was essentially exploring the methodology for assessing witness Goggins' approach to system marginal cost and whether the company provided sufficient information to support that alternative analytical approach. Do you recall that?
I do.
Okay. And that is the analytical approach that witness Goggins used to support the proposed disallowance of $15.7 million of fuel costs that are associated with coal plant dispatch at issue in this proceeding. Is that correct?
That's correct.
And can you explain to the commission why, in the company's view, that system marginal cost or system lambda approach is not a reasonable methodology to disallow costs, and then explain why, in the company's opinion, you reasonably dispatched these coal units during the periods of time that he alleges were uneconomic? And that may be for you, that may be in part for Mr. Lloyd, for Mr. Flanagan.
Well, I'll start with just a brief overview of our unit commitment process. So like I said in the testimony, but it's basically we have a process designed to serve our customers economically and reliably. And we start with 7 days and out. So 7 days and out, we look at weather, we look at the expected customer demand from that weather, those weather conditions. We incorporate all the generation, the availability of each generator. So which ones can you run, which ones can't you run, which ones are on maintenance. And then we incorporate the cost of each generator and any additional parameters, such as physical parameters, like how quickly can it start up, can it shut down, things like that. And we run that production cost model, and the results of that model serve as a guideline to say, this is how we are going to plan on serving that customer demand for the next 7 days economically and reliably. Mr. Lloyd explained that doesn't always occur, right? So there are times when we deviate from the plan in reality because conditions change. Units come offline, weather is different. But that's the design of the GenTrader unit commitment process. And then I think the first half of your question was why, in my opinion, is Lambda not an appropriate, why his use of Lambda was inappropriate, basically. And I think there's the biggest thing I saw in Mr. Goggins' analysis was the assumption that all 3,000, so this is roughly 3,143 megawatts of capacity. The assumption was all that capacity could be replaced at that single incremental cost Lambda price. that's the biggest fallacy and assumption I saw. There was no look at, I think Mr. Goggins this morning stated that lambda is relatively flat. And that's true at times. At 3 a.m, that lambda curve is relatively flat, meaning there's more than 1 megawatt there. But that's certainly not true in every hour. And there are going to be many hours when that lambda, you can't replace, you can replace the first, say, 50 megawatts at that price. But as you replace more and more and more, it gets more and more and more expensive to where it's not even anywhere near the original lambda price. So that's the biggest fallacy. I identified other things in my testimony or our testimony, but that was the biggest fallacy I saw.
Thank you for that. And then Mr. Magaria today, and I don't have the exhibit number here, but in one of the exhibits was identifying where there were, in the hours that SACE has identified what they perceive as uneconomic operation of coal units, that there was available capacity on the system that the company could have used as an alternative. Do you recall that?
I recall the discussion, yes.
Okay. And maybe Mr. Flanagan, start with you, and then if Mr. Lloyd has a perspective to add from the real world operation of why the company's coal plants may have been operating during these periods, and why from a real world operations perspective, it's not necessarily feasible to just shut these units down and start them back up, and why it may be operationally appropriate and necessary to run them even if there is other available capacity on the system.
Yeah, so, one of the, is my mic working? Yeah, okay. One of the, issues, and it kind of goes back to your previous question with Mr. Goggins. I took note during his testimony, he mentioned decommitting coal units, and he made the comment of turning them off and turning them back on. The real world, for what that looks like, is significantly different than turning it off and turning it back on. For one, we talk about the, thermal cycles that puts the facility through, the boiler, but, you're taking, hundreds of valves are closing and motors are turning off. And, to turn that back around, you've got, 4,000 volts of electricity jumping into a motor, right? It incurs a lot of risk that taking a unit out and turning it back on, it's a lot more complicated than it seems. Not to mention, we publish startup times and shutdown times, and it's not just a matter of decommitting one for 3 hours. I know some of the questions were around a specific 3-hour time frame. You can't just shut everything down, bottle it up, and then turn it right back around, right? It's all these systems that are cooling off, that are shutting down, that then have to start back up, and you have to expect them to operate reliably with equipment that's 65 years old. That's not always the way that it can work. So
that's helpful. And then from Mr. Lloyd, your perspective as the system operator that collaborates with Mr. Flanagan in the plants, can you also speak to how you've dispatched these units in real time, and why some of the constraints that have been imposed on shutting them down may make a paper exercise suggest that it was uneconomic, but in actuality, it was necessary and appropriate from a reliability standpoint to run these plants as you have during the test period?
Right. So Mr. Suez and Mr. Flanagan both have spoken to it. So I'll start with Mr. Suez's operating plan, the 7-day plan. So those reliability, I guess, inputs that sometimes can't be captured in the model, that's what my team's there for. So my team takes a look at that 7-day plan, and we look at the risk that Mr. Flanagan mentioned of shutting a unit down and bringing it back on. If we deem that it's a high risk, or maybe there's a probability that that unit can't get back in time for that next peak demand, we recommend that we do not shut those units down and we keep them online in order to reliably serve that system of demand over that 7-day period.
Thank you. And this may be for you or for Mr. Suez, but there was a question from Mr. Margarita about solar. I think maybe it's an assertion. Solar is a zero fuel resource, but for much of the company's solar, it's purchase power, and so it does have a cost associated with it, correct?
That is correct.
All right, thank you. And then towards the end of his examination, Mr. Margarita walked you through a number of operating procedures that affect when coal units in DEP's coal units, which to be real practical about it, they're all in Person County. They're in a fairly, discrete location, which is close to other key plants and key loads on the company system, are required to run. And I just want to make sure you have the opportunity to fully explain how those operating procedures work and why they support running the coal units during certain periods where, based on the analysis, the paper analysis that Mr. Goggins did, it may be perceived as uneconomic based on the real-time marginal cost. And please do so in a public setting. And if you feel like we need to go in a confidential setting to more fully explain it and refer to the documents, we certainly can.
No, I think I can keep it high level. So a part of our responsibilities as balancing authorities and transmission operators from a NERC standpoint is that we, from a system standpoint, and I think Commissioner Vandervoort mentioned it earlier when he talked about what if you lose a unit. So we have to be able to withstand the loss of the next thing, whatever that thing may be. So I think what the council was getting at is, I think he may have misinterpreted the purposes of that document that we were speaking of. We have to have those things online ahead of the loss of that unit to be able to withstand it, is the shortest version, highest level version that I can give.
Okay, thank you. And Council Versace's final Q&A and exhibit was to point you to the fuel statute and say the company has the burden of proof to demonstrate that your fuel cost incurred that you're asking to recover from, by this commission from customers were reasonable and prudently incurred. Based on the entire record presented, is it your testimony that all of these fuel costs and the coal unit related dispatch costs were prudently incurred and should be recovered from customers in this case?
Absolutely.
Thank you. No further redirect.
We'll now move to commissioners' questions. I have I think just one question, and then I'll look to my fellow commissioners. And this is probably a question directed to either Mr. Flanagan or Mr. Lloyd. It relates to Mr. Bryceworth's, one of his last questions about shutting down the coal plants. And I thought I heard Mr. Flanagan and then Mr. Lloyd say that, talking about the risk of shutting down essentially 65-year-old coal units and the risk of shutting them down, and then stating that at the same time DEP is expecting them to operate reliably. Can you provide a little bit more context or information about the specific risks for reliability that you're talking about in relations in particular to the shutting down and then having to return the units to operation? And related to your comment about them being 65 years old, aging assets.
Yes, and so I guess if you look at some of the examples that were given earlier, where there's periods of high temperatures, and then you've got a couple of days of relief, and then it gets into a high temperature period again. The question was really around, do you decommit those units for a day or for a day and a half? And really with any equipment, the more you start it and stop it, could be the starter in your car, right? I mean, any equipment like that is going to include some amount of risk to go through that cycle. And, you add to the fact of, the coal units have some age on them. It just increases that likelihood. And, the thermal stresses, we've talked about that with, what the boiler goes through. You're a lot more, you reduce a lot of risk by keeping the unit online, whether it's at minimum load. A good example, and this is outside DEP, but so at Marshall, we've had a unit that had an issue recently, and we were able to keep it at a steady load for 100 days, and the unit ran for 100 straight days, just because you're not putting it through those thermal cycles. So, to take a unit off and then put it back on in a day period, just exacerbates that risk versus, the way they're saying to operate the units that Mr. Lloyd can speak about.
Yeah, and the only thing that I'll add is that my team is in constant communication with all of the plants, the individual plants, and they have conversations about what risk, what kind of little items that the unit has been dealing with over the course of the past couple of days and looking into the next 7 days. So my team is informed about some of the risks that are being carried, and then from there they make the decision whether or not they want to keep it on or not.
Let me check to see if there's any questions. Commissioner Vandervaart.
Yeah, I've got one question. Just want to follow up real quick. I mean, not only are you talking about reliability, but there's a cost associated with those, with the cycling, right? I mean, you all are maintaining these facilities, and the more you cycle them, the more you're going to have to spend to keep them operational. So there is a cost associated with backing them off, but that cost isn't isn't deferred to the solar entity. The coal units are charged those. Is that right?
I will say, I can't speak to the solar side, but I can say, yes, there is a cost. And, that's one thing I think in Mr. Goggins' assessment looked at the startup and shutdown costs. But, what you're speaking of is different than that, right?
Yeah.
There is the more you cycle units,
Yeah.
there's a added maintenance cost. Absolutely.
Right. So just to get back to the question at hand, and this may be too simple, but is the intervener, we have a lot of solar penetration, and on a regular day, there's a ton of solar megawatts. I call them maybe watts, but megawatt hours that are being produced during the day. On a perfect scenario, don't you still keep those coal units warm because you're going to have to ramp up at the end of the day, and you're coming off of the morning? I mean, isn't that a standard operating
Yes,
procedure?
and I wouldn't call it warm. I mean, they have a minimum load, right? They have a minimum operating load.
Right, but I mean, they're not cold shutdowns. I mean, these things are still.
I mean, it depends on what the cycle time is, right? If the units are coming off for.
But I'm talking about a regular 20, like say every day the sun's going to come up, and we're actually going to get a pretty good solid solar generation. You're still getting ready for 5:30.
Correct, and they'll run to minimum load, but it's not like they're coming.
Right, but so in that scenario, during the peak, 2:00, the price, because we have so much solar, the price on a instantaneous basis, which I guess is the system lambda, doesn't that get to be pretty low? The price of a megawatt hour during that period. I mean, you've got so much solar on the system. You've backed out your coal units as much as you can, or as much you're willing. Is that a loss? Are those considered in this scenario, in this calculation that's being presented to us? Are they, Mr. Goggin or somebody, is that being charged as a loss right there? Because those are low prices, and yet you're still paying money to keep those coal units running at a low level. But that's still a price that's going to be higher than these, because that price dips during the day, right? Am I missing something? Is that too simplistic?
No, that's exactly right. So basically what you're saying is during the highest solar parts of the day, that would tend to be, let's take a spring day, that would tend to put a suppressive effect on the incremental cost, or lambda. So you'd have a lower lambda. The analysis basically takes the cost, the period which the coal unit was run. He took the difference between the production, my understanding, he took the difference between the production cost of the unit and that incremental cost. And that was basically a loss. And
It's going to be a loss all day long.
Until the sun goes down. And
right. And so it's incredibly myopic to focus on that period and say, oh, we got a loss. Oh my God. Right. Because if you look just a little bit, a couple hours on each of the shoulders, all of a sudden that loss becomes a profit. You're starting to make money again.
Well,
I mean, that's just simplistic, but
his analysis, he did go out like multiple days. So it incorporated both the losses and the gains, and losses and the gains. It was over multiple days. My biggest problem was, again, the fact that there was, I don't know what those 3,143 megawatts.
He had an infinite supply of constant price megawatt. I don't know where that. I mean, it's an inelastic price, I guess. Do you think it's an inelastic price market in megawatt hours, Mr. Lloyd? You wouldn't be here if it were, would you? Okay, that's all I got.
Commissioner Tucker.
Yeah, just one question from my own edification. Do all the coal plants run on minimum load all the time, except for when you're pulling maintenance, or they're shut down for maintenance?
We have periods of reserve shutdown. So there are times when we do take units off on reserve shutdown, and they're just off.
Okay.
Yeah. But available to come back online. That does happen.
All right. Thank you, Mr. Sweat. And the last question is, do all the coal plants have scrubbers on them?
Yes. Yeah.
What kind? Water molecule, bag houses, what?
So all of the units, so all the DEP units have wet scrubbers. There's Cliffside 6 is a little bit of a different animal. It's got a wet and a dry, I believe.
Okay.
Yeah.
Okay, but all of them do.
Correct. Yeah. So precipitators for particulate, SCRs for NOx, scrubbers for SO2 removal. That's correct.
So Duke's taking every precaution on all the coal plants to make sure there's no particulate
That's
being
correct.
released as best you can.
That's correct.
Okay, thank you.
Okay, so we'll move to questions on commissioners' questions. Okay, NCSEA.
I'm going to just have one question, and it's follow up on Commissioner Tucker's last question about talking whether or not coal plants are operating at minimum load, and your response was about reserve shutdowns. Can you just sort of elaborate and discuss the value of capacity versus the value of energy, and why there's still benefit even during those minimum load days? Like, coal provides a capacity value too, not just an energy value.
Correct. Is your question on the value of capacity from a long-term planning perspective, or just like, and I'm not sure exactly the question.
Well, I think you're getting at my question. We're talking about the value of energy in a given period of time through this analysis, and there's differentials between when that energy has value throughout the day. And your testimony and some of your answers, we're talking about the different times of day there's value in energy. So the minimum load capacity of coal, that still means that that energy is being served by other resources because there's value and there's energy on the grid.
So I think we might be talking about two different things maybe. So I mentioned reserve shutdown. So there are times when we do take our coal plants off during low periods, and they're off. And then there are other times when the unit commitment process deems that the most economic thing to do and reliably serve our customers is to leave the unit online, so leave it committed. But then Cedric, Mr. Lloyd's group, is able to ramp it down to minimum load. So it's still online, but at minimum load. And certainly when it's at minimum load, it has value because they can go back to full load. I'm not sure if that's helping or not.
No, I think it helped clarify the question, just so that I understood. Thank you.
Are there any additional questions on commissioners' questions?
No questions. Thank you.
No questions? Okay, I will take motions beginning with DEP.
Thank you. If we could please move the panel's rebuttal exhibits into the record, which there were.
Seeing no objection, the panel's 2 exhibits will be entered into the record.
Thank you.
And I will next take motion from NCSEA.
At this time, NCSEA would like to move into the record NCSEA Duke Cross Rebuttal Swez Floyd Flanagan Confidential Exhibit 1.
Okay. And for clarity of the record, I think that I gave differing information about how to identify the exhibit. So I'm going to state it very specifically for both NCSEA and for SACE. And I will make your motion. I will, for SACE, I will tell you how to identify the exhibits for the record, but we will, I will accept into the record NCSEA Cross DEP Operations Panel Rebuttal Exhibit number 1. So your motion is allowed. Okay. And now, SACE, I will receive your motion.
At this time, SACE et al. Would move into evidence. And please correct me on this first one if I have it wrong. So
if you just want to list the number of exhibits, and then I will state how they are to be identified for the record.
Okay. So the first exhibit was initially identified as SACE et al. Potential cross exhibit 20.
And I can shorten this if you want to make a motion to enter into the record exhibits 1 through 8, and then I will identify them for the record.
One clarifying question. 6 of those have confidential information. Are you okay with me just identifying them just blanketly, notwithstanding that they wouldn't be designated confidential, not confidential?
I will state how they are to be identified, and
Okay.
I will note those confidential designations. So seeing no objection, I will admit into the record SACE et al. Cross DEP Operations Panel Rebuttal Exhibit Number 1. SACE et al. Cross DEP Operations Panel Rebuttal Exhibits 2 through 7, which are confidential, and SACE et al. Cross DEP Operations Rebuttal Exhibit Number 8, which is non-confidential. Is that correct?
That's what I have.
Okay.
Thank you. I appreciate it.
Those 8 exhibits will be entered into the record. Are there any additional motions that need to be made for this panel? Okay. With that, thank you for your testimony. You may step down and be excused.
Thank you.
And DEP, when you're ready, you may call your next panel.
Thanks.
Thank you. At this time, I will call witness Sykes as well as witness Harrington to the stand.
Good afternoon. If you can place your left hand on the Bible and raise your right hand, and do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Before we begin, Ms. Harrington, will you please confirm that you were in the room when presiding commissioner entered your direct testimony, supplemental testimony, and summary of your testimonies into the record?
Yes, ma'am.
And won't you still take the opportunity to introduce yourself to the commission?
Just my name.
Your name and your title.
Okay. My name's Dana Harrington. I'm a rates and regulatory strategy manager with Duke Energy.
Mr. Sykes, please state your name, business address for the record.
My name is Brian L. Sykes, and my business address is 525 South Tryon Street in Charlotte.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Progress as Director of Rates and Regulatory Planning.
What are your responsibilities in that role?
So my responsibilities include the oversight of numerous annual rider proceedings on behalf of both Duke Energy Progress and Duke Energy Carolinas.
Ms. Harrington, did you cause to be pre-filed in this docket joint rebuttal testimony along with Mr. Sykes consisting of 27 pages and 6 revised exhibits?
Yes, I did.
Do you have any changes to your joint rebuttal testimony at this time?
No, I do not.
If I were to ask you the same questions today that appear in your pre-filed joint rebuttal testimony, would your answers remain the same?
Yes, they would.
Your joint rebuttal testimony does not include confidential information, is that correct?
That's correct.
And your pre-filed summary of your joint rebuttal testimony and you've also pre-filed a summary of your joint rebuttal testimony for the commission, is that correct?
That is correct.
Presiding Commissioner, I would ask that Ms. Harrington and Mr. Sykes' pre-filed joint rebuttal testimony be entered into the record as orally given to the stand, as well as the summary of their joint rebuttal testimonies, also pre-filed with the commission.
And for clarity of the record, can you check their rebuttal testimony? My notes show, and they could be wrong, but they show 27 pages with 2 appendices and 9 exhibits. And I think you mentioned 27 pages and 6 revised exhibits. So I just want to make sure that the record is correct.
There's 6 revised exhibits, 6 exhibits, rebuttal exhibits. Is that what you're expecting? And the appendices, A was the rates with and without rate fees, and B was public notice. Is that what you were asking, A and B?
Correct. So it sounds like we have 27 pages and 2 appendices and 6 revised exhibits. Is that correct?
That is correct. Appendix A and Appendix B.
Okay. And one other matter for clarification, you stated that there was no confidential information, but just to make sure that we're very clear for the record, the rebuttal testimony, my understanding, was filed as a combined document with witness Suez's rebuttal testimony that may have contained confidential information. So how does DEP want us to handle this rebuttal testimony? As non-confidential, or does it need to be filed confidentially?
Non-confidential.
Non-confidential. Okay. Seeing no objection, the joint rebuttal testimony of DEP witnesses Harrington and Sykes, consisting of 27 pages and 2 appendices, will be entered into the record as if given orally from the stand, and the 6 revised exhibits will be marked as identified.
Thank you. The panel is now available for cross-examination and questions from the commission.
Okay. Let's begin with NCSEA.
Thank you. Can you both please turn to page 25 of your rebuttal testimony?
Yes, sir.
Thank you. And on page 25, line 12, you explicitly reference Commission Rule R855K as the grounds for disallowance.
That's right.
In front of you should be a binder. It's Sace et al.'s pre-filed potential cross exhibits. I think it's a skinny binder.
Do we share?
Yeah, I'm just
Okay.
going to ask you to go to the potential exhibit 9, which is Rule R855K. And presiding Commissioner Kemmerer, while they get to the rule, would it be proper to introduce the Commission's rules as an exhibit or judicial notice?
I think judicial notice will be appropriate, and Commission will take judicial notice.
Okay, thank you. I am going to take this in pieces, and I understand I'm not going to ask you to interpret the law. I just want to see, to clarify into the record what the law, what the Commission rule says. So, and subsection K starts off by memorializing the statutory rule where it says the burden of proof as to the correctness and reasonableness of any charge, and as to whether the test year, cost of fuel, and fuel-related costs were reasonably and prudently incurred shall be on the utility. Correct? And then the Commission rule elaborates a little bit and outlines some objective standards, mostly pertaining to nuclear energy, correct?
I do see nuclear noted, yes.
Yes, and no other types of fuels are mentioned in this rule, correct?
And that's in this subsection.
In this subsection. Oof, we don't have a control F. I think I can do that part in the legal briefing because I know I'm crossing a tightrope right now. But understanding that there are objective standards for nuclear energy in this rule, given the rule silence, we are going to need to rely on the Commission's expertise to adjudicate other rules that are not explicitly mentioned, correct?
We're before the commission for their judgment on the entirety of the proceeding. So I'm not sure if where you're splitting hairs on there.
No, I'm just making sure that it is the Commission's responsibility to determine whether or not the company's met their burden of proof, correct?
Yes, yes. And in subsection F, is that the one you said you don't have F?
No. That was a Microsoft Word joke. I apologize.
Okay. Yeah, in subsection F, yes, the commission will determine if that burden of proof has been met.
Okay. And just for clarity of the record, we're talking about subsection K, Rule RA55K.
Okay.
But knowing that we need to rely on the Commission and it is their duty to determine whether the burden of proof has been met, does the Commission also have the authority to further study issues and receive more information to help make more informed decisions that better balance the rates, the interests of ratepayers and the utility.
I would think so, yes.
Okay. With that, I think I navigated my tightrope without an objection from opposing counsel, and I'm going to stop my questionings on the commission rule.
So we'll now move to cross-examination from SACE.
Sorry for any confusion, but SACE et al. Has no cross-examination reserved for the panel.
That is correct. We will now move to redirect from DEP.
No questions from the company.
Okay. I have a couple of questions from Ms. Harrington. And Ms. Harrington, you did not testify on direct or supplemental testimony. Our staff has a couple of just clarifying questions for you, and I thought it'd be more expedient to just ask you during your rebuttal testimony so that we did not bring you up twice. So in your, I believe it's your direct testimony on page 10, you describe a reporting error and the adjustments made to correct it. And the question that we have is, can you explain why DEP proposes applying two over-recovered amounts to different billing periods, please?
I sure can. So the review period in this case would be April of 24 through March of 25. And so that puts bookmarks around the costs that are in the EMF proposal in this case. And some of this correction is applicable to that time span. In the prior year proceeding, we did do an update period extension. So in the prior proceeding, we also grabbed the April, May, and the June. I misspoke. We grabbed the April, May, and the June of 24, rolled them into the prior year EMF rates. In this proceeding, we've extended the update period to be April, May, and June of 25. So we've kind of done the same thing we did last year. So the test periods are aged as 12 months ended March, but there's flexibility with which end cap 3 months you can put into which period. So when this resolution was determined in totality, it spanned two different EMF proceedings. And that's why there's two. The costs that are on my Exhibit 3 in this case, which are the substantiation for the EMF in this proceeding, are aged, I'll use the language aged as April, July of 24. And then we did the update period, so through June of 25. So the first adjustment noted, I believe it is, yes. So on line 19, page 10, the first adjustment is applicable to that term. It was a lesser term because we discovered the issue and made resolution by November of 24 was once the final month of that error correction. And then the other portion is not in any of the rates before the commission today. The other adjustment, that would be proposed when we handle the true-ups of true-ups in a future case. So it was last year's EMF that is yet to be revisited for full collection or full return to customers. And that amount will apply in that series of balances.
Okay.
I'm sorry, that's a long-winded. It's a tricky stagger period.
Yeah, thank you for the explanation.
I'm sorry.
So one more question related to your direct testimony, and then I'll move to rebuttal.
Okay.
On page 12 of your direct testimony, and this is lines 8 through 10.
Yes.
You testify that DEP will provide transparency to the commission regarding DEP's known and measured fuel balances recovered through the fuel rider process. And can you provide some additional information about what specifically DEP is going to be doing to provide that transparency?
Certainly. So there's multiple places within my testimony in this proceeding where we discuss EMF true-ups of prudently incurred cost balances that have been approved by the commission for recovery. So once an amount is deemed prudently incurred by the commission and deemed appropriate for customer rates, we will implement the rate that the commission approves, collect those monies on a cents per kilowatt hour basis as they're charged, report that to the commission in full, with the consideration that these rates run for 12 months. So if a rate runs 8 months, we don't have any in this proceeding that have had a shortened term than the 12 months. We've got those. Those will be presented on exhibits in full. These were collected from this docketed rates. These were collected from these docketed rates. And here's the simple math to show the net balances. So they will be exhibits and, if necessary, narrative response as well.
Okay. And what is the frequency of that reporting that you're anticipating to the commission?
For starters, we're thinking the 2026 proceedings. So annual proceedings unless otherwise directed.
Okay. Okay, and now I'm going to move to questions to either of you relating to rebuttal testimony. And I think I just have one question. And this relates to testimony that you provided on pages 20 through 22 of your rebuttal testimony. And I'll just go ahead and paraphrase what you stated on those pages, but you respond to the public staff's concerns regarding DEP's proposed methodology to address the EMF balances. And then on page 22, lines 5 through 9, you state that DEP anticipates its proposed method will likely result in an under-recovered EMF position in the next fuel proceeding, but that going forward, it is just as likely to result in over-recoveries as under-recoveries. Can you explain why DEP believes going forward that under-recoveries will be just as likely as over-recoveries?
Yes, each time we set a rate, it's always contingent on an estimated projected sales, whether that's normalized test period sales or projected future sales. So once you set a rate, you're setting that established on a speculative number of kilowatt hours billed. So when you determine that on a speculative basis, once the actuals start coming in, they're just as likely to be more than or less than. One's neither more likely than the other. It's always in relation to that estimated kilowatt hours component. So a forecast is a forecast. We don't know if the weatherman today is going to give us two degrees too high or 2 degrees too low. It's going to likely bounce around what we set the rate on in terms of projected kilowatt hours.
Okay, thank you. That's all the questions I have. Let me check with my fellow commissioners. Okay, seeing none, I'll move to questions on commission questions, and I will, having noted that I did ask questions related to witness Harrington's direct testimony, so I will allow questions about direct testimony specifically related to those questions, if there are any. Okay, seeing that there are no questions on commissioners' questions, that concludes the testimony for this panel. You may step down and be excused, and I will accept motions from DEP in regard to this panel.
Presiding Commissioner, at this time, I'd move that the rebuttal panel's 6 exhibits and 2 appendices be moved into the record.
Okay. Seeing no objection, the 6 exhibits and 2 appendices will be entered into the record. Okay. Those are all the exhibits you identified initially.
Yes.
Okay.
And Presiding Commissioner, would you mind confirming that whether I moved the application into the record this start?
And I specifically remembered that you did. I specifically remember that you did make that motion, and I approved your motion, and it has been entered into the record. Yes.
I appreciate it. Thank you.
So we've heard from all of the witnesses, and before we conclude the hearing, are there any additional matters that need to be heard or any additional motions that need to be made? I think that we've already admitted all of the testimony. the application, and all of the exhibits into the record. Is there anything in addition?
Nothing.
Okay. With that, we'll go ahead and conclude this hearing, and I'll remind the parties that proposed orders are due to be filed with the commission no later than Wednesday, October 22nd, 2025. And thank you to all of the witnesses and to the attorneys for their work for this hearing. With that, we will stand adjourned and go off the record.
is Donald Vandervaart. I'm a commissioner on the North Carolina Utilities Commission. With me this afternoon is Chairman William Brawley and Commissioners Karen Cameron and Tommy Tucker. I will now call for hearing docket E2 sub 1355, the matter of application for Duke Energy Progress LLC for approval of CPRE cost recovery rider pursuant to North Carolina General Statute 62-110.8 and Commission Rule R8-71. Before we proceed, according to North Carolina law, I reminded the members of the commission it's our duty to avoid conflicts of interest and inquire at this time as to whether a commissioner has any known conflict with respect to this docket. Seeing none, we will let the record show. I see no such conflicts being identified. So on June 10th, 2025, DEP filed an application for approval of CPRE cost recovery rider, as well as the direct testimonies and exhibits of its witnesses, some of which is confidential. The Carolina Utility Customers Association and SIGFER petitioned to and have been allowed to intervene in this proceeding. On July 15th, 2025, the Commission issued an order scheduling hearing, establishing procedural and filing requirements, and requiring public notice. On July 18th, 2025, DEP and the public staff filed a proposed public notice. On July 23rd, 2025, the Commission issued an order approving the public notice. On September 2nd, 2025, the public staff filed affidavits of its witnesses. On September 16th, 2025, DEP filed a letter in lieu of rebuttal testimony. On September 17th, 2025, DEP and the public staff filed a joint motion to excuse witnesses from attending the hearing. On September 22nd, the Commission issued an order denying the motion to excuse. Public staff, which represents the using and consuming public, have been made party to this proceeding in accordance with North Carolina law. That brings us up to today. I will now call for the counsel for the parties to introduce themselves for the purposes of the record, beginning with the applicant.
Good afternoon, Presiding Commissioner LaDon Tune on behalf of the applicant.
Welcome again.
Good afternoon, Presiding Commissioner Vandervaart, Peter Ledford of the law firm Morton Smith, on behalf of the Carolina Industrial Group for Fair Utility Rates 2 and the Carolina Utility Customer Association.
Thank you very much.
Good afternoon, Presiding Commissioner Vandervaart, Commissioners Tom Felling with the public staff on behalf of the using and consuming public.
Very good. So first, are there any preliminary matters that need to be addressed at this time? No?
None.
Seeing none, let's proceed with the expert witness portion. And for that, I guess we're going to first do it by two-person panels. Oh, sorry. Let's first make sure that we include in the record your DEP application for approval. You want to make a motion on that?
I would. Thank you, Presiding Commissioner. At this time, I'd ask that the company's application consisting of 7 pages be moved into the record.
So moved. All right. Now we're going to call your witnesses, I think.
Yes.
Have at it.
At this time, I would call witness Walker and witness Tabor to the stand. Just be careful stuff.
And if I could get you all to put your left hand on the Bible and raise your right hand. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, and go ahead and enter them in.
Thank you. Ms. Walker, would you please state your full name and business address for the record?
Yes, my name is Christy J. Walker. My business address is 525 South Shrine Street, Charlotte, North Carolina.
By whom are you employed and in what capacity?
I am a Rates and Regulatory Strategy Manager for Duke Energy Progress.
Can you please briefly describe your role and responsibilities at Duke Energy?
Yes, I am responsible for providing guidance on compliance with and cost recovery related to program for competitive procurement and renewable energy.
Are you the same Ms. Walker, that caused to be pre-filed on June 10th, 2025 in this docket, direct testimony, which consists of 12 pages of direct testimony, as well as 7 exhibits and 7 work papers.
Yes, I think that's 14 pages. Yes.
And was this testimony prepared by you at your direction?
Yes.
Do you have any changes to your direct testimony at this time?
No.
And if I were to ask the same questions today that appear in your pre-filed direct testimony, would your answers be the same?
Yes.
And with respect to your exhibits, can you please confirm that exhibit 1 and 2 includes confidential information? And with respect to your work papers, please confirm that work papers 1, 2, and 5 also include confidential information.
Yes.
Did you also prepare and cause to be pre-filed in this docket a summary of your direct testimony?
Yes.
Turning to you, Ms. Tabor, would you please state your full name and business address for the record?
Yes, my name is Angela M. Tabor, and my business address is 410 South Wilmington Street. That's Raleigh, North Carolina.
And by whom are you employed and in what capacity?
I'm a renewable compliance manager for Duke Energy Progress within the Business Development and Compliance Department.
Can you please briefly explain your role and responsibilities at Duke Energy?
My responsibilities include compliance and administration of the CPRE program, as well as being the subject matter expert in the annual rider filings with the North Carolina Utilities Commission.
Thank you. And are you the same Ms. Tabor that caused to be pre-filed on June 10, 2025 in the docket, direct testimony consisting of 9 pages?
Yes.
And was that testimony prepared by you at your direction?
Yes.
Do you have any changes to your direct testimony at this time?
No.
If I were to ask you the same questions today that appear in your pre-filed direct testimony, would the answers be the same?
Yes.
And portions of your direct testimony include confidential information. Is that correct?
Yes, that's correct.
Did you also prepare and cause to be prepared in this docket a summary of your direct testimony?
Yes.
Presiding Commissioner, I would move that Ms. Walker's direct testimony, exhibits with the confidential markings as appropriate, and work papers also with the confidential markings as appropriate, and summary of testimony be marked for identification as pre-filed and enter the record at the appropriate time.
Any objections? So moved.
Thank you. I also move that Ms. Tabor's direct testimony and summary of testimony be pre-marked for identification as pre-filed and entered to the record at the appropriate time as if orally given from the stand.
Any objections? So moved.
And that testimony be marked as confidential given those.
I understand.
Thank you. At this time, the panel is available for.
Did you want to move the summary into the record as well?
Yes, please.
You're going to have to make
May I
a motion.
request? No, apologies. At this time, I'd also request that Ms. Tabor's summary of her direct testimony, which was also filed in the docket, be moved into the record as if orally given from the stand and also marked as confidential.
Any objection? So moved.
And now the panel is available for questions from.
Good. And so I have no intention of getting into anything confidential. I'm actually going to ask you a couple of sort of method questions, but, please stop me if somehow it goes into the confidential realm, which I can't imagine. And so I'm just going to ask you all questions. Whoever wants to can answer. Okay. So it's my understanding under the CPRE program that the project the solar projects that are considered must be less than the utilities avoided cost. Is that correct?
Yes, that's correct. The avoided cost is the measure for projects under HB 589.
And in the practice, is the avoided cost benchmark usually tied to the cost of a simple cycle combustion turbine?
I'm not the expert for avoided cost. I just know that's the metric that we use when evaluating the CPRE projects.
Okay. All right. So you wouldn't know, for example, what the capacity factor is that is assumed when calculating the simple cycle avoided cost?
No, that's not part of my area.
Gotcha. Okay, that simplifies the questioning a little bit. Let me move on. So the idea is that the solar project, the bid into the CPRE, it's compared to this avoided cost number. And if the solar price is below that figure, it's deemed less than the avoided cost, and therefore valid for the CPRE. Is that more or less correct?
So for CPRE, the bidders actually bid a decrement to avoid a cost at the time that they submit their bids into the CPRE program. And the two projects that are online and operating today that we're looking at their cost in this filing were both bid in that way, a decrement to avoid a cost.
And when looking now, so we talked about the avoided cost being something to do with the combustion turbine. When you look at the cost of the project, you don't look at any firming prices for the in this case standalone solar projects.
That's correct. So for these projects, CPRE 589, the companies worked with an independent administrator, and that independent administrator was part of the evaluation of the bids that were submitted for these tranche one projects that we're here to recover on costs in this rider.
Okay, so do you have a notebook in front of you, and in the back there is a DEP Roxborough steam plant application? Could you turn to that, specifically turn to page 2-9? You found that?
Is it the evaluation of alternative sources of flexibility? That page?
2-9, the top says failure to match.
Yes.
Okay.
Yes, I'm there.
Okay, so can you all draw lots and decide who's going to read something for me? Either one. I need paragraphs 2, 3, and 4. Whoever could do that.
I can go ahead and read those. Let it be noted that this is not my words.
I
These are
understand.
the words in the exhibit that you've provided.
And
So
and what is, we should say what that is. Do you know what this is, this document?
this looks like the minor NSR permit application for the combined cycle turbines project. Duke
Submit-
Energy Progress Roxborough Steam
Right.
Electric Plant from March of 2024.
Right, so it's submitted by Duke Energy.
Correct.
Okay, now you can slog through those 3 paragraphs if you don't mind.
As solar capacity increases on the bulk electric system, so does the importance of regulating reserves. A substantial amount of regulating reserves is required in the downward direction to accommodate the rapid increase of solar output as the sun begins to rise in the morning. Likewise, regulating reserves in the up direction are required to replace the loss of solar generation as the sun begins to set in the evening. Throughout any given day, regulating reserves are required in both directions to cover the change in solar output that comes from cloud cover, rain, or anything else that impacts the sun's intensity. For example, an overcast sky can reduce a solar facility's production to as low as 15 to 30% of its rated capacity. This variability in solar output, whether predictable or not, requires an increase in regulating reserves to maintain an acceptable match between demand and generation within the operating area. Failure to maintain adequate regulating reserves would result in excessive inadvertent interchange with neighboring control areas and could also potentially threaten the integrity of the bulk electric system. Gas-fired generating units have a relatively high ramp rate when compared to most other generating technologies. Gas-fired units are also typically cheaper to operate from a fuel cost standpoint. These two factors position gas-fired units to provide much of the needed regulating reserves to accommodate the increase in solar penetration in North Carolina.
Thank you for that. So is Duke saying in this application that regulating reserves, as they call it, and they give one example as a gas-fired generating unit, are they saying that regulating reserves are needed? I'm looking at the last sentence, are needed to accommodate the increase in solar penetration in North Carolina?
That's how I understand it.
Thank you. And if you, perhaps Ms. Walker, can read if you look at the last full paragraph, starting with Duke Energy, if you could just read that one paragraph through to where it says flexibility.
Duke Energy evaluated several alternatives to address the minimum load and ramp rates associated with solar integration. These options include the sale of excess energy, curtailing coal plants, curtailing nuclear plants, curtailing solar, energy storage, and demand-side management. While several of these options, including the sale of excess energy, curtailing solar, energy storage, and demand-side management, can contribute to grid flexibility and in solar integration. None of these alternatives can substitute for increased natural gas operational flexibility.
Thank you. So is Duke saying that at least of the options considered, natural gas combustion turbines are best suited to substitute to provide this flexibility?
That's what I interpret. However, I'm not a subject matter expert in this area.
Thank you. And just to come back around, I think you've already answered this question. In the comparison that you do to determine whether a project fits into the price tag is less than the avoided cost, no such firming or regulating reserves are included in the cost. You're only going to cost the standalone solar facility. Is that right?
That's right.
Okay. No more questions. Do we have any questions? Or do we have any other? No, first of all, no. Do we have any other questions from the commission? Sorry. Okay. You want a question? Yes. Go ahead. Okay. Go ahead, Commissioner.
Here all day. Through this process for the most of the time, I'll have quick questions just for some of them my edification, some of them maybe for the public. Ms. Walker, your chief responsibility or one of the central responsibility is that you procure the competitive renewable energy for your job description.
I maintain compliance with the rule R8-71. I'm in compliance and help set the rates and make sure the costs are prudently incurred.
Your testimony on page 3, and I guess the new line 18.
Okay.
Yeah, just explain to me about the 1% in your work, please.
Yes. So on my, I think it's Exhibit 6, we do a calculation where we determine that the costs do not exceed 1% of Duke Energy Progress's revenues.
That's on exhibit.
I'm going to look for it for you. Maybe not work paper. Yeah. It's on work paper 6.
Commissioner Tucker, you might want to talk into your.
Turn it on, see what happens. That would help. Ms. Walker, on page 6, in lines 2 and 3, you over collected, it states $1 million during the EMF period, and in addition, the company received 4.4 million in one-time revenues. Is that from the Marley Solar project?
Yes, that's from the Marley Solar liquidated damages.
And those, I know the 1 million is going to be returned as an over collection. What about the liquidated damages at approximately 2.7 million on line 6? Where did those monies go?
Those monies are refunded to the customers.
Okay, so DEP is having roughly 5, 6, 7, maybe $8 million returned to the customers. We total all those? Just a guess.
They're having 2.7 million returned related to the liquidated damages. That's a North Carolina retail
Okay.
allocation portion.
Okay, all right, that's fine. Okay, let me see here, just a second. Not that. Tell me, share with me what impact, well,
Commissioner Tucker.
did you,
Commissioner, I couldn't recognize it if it bit me, but that wasn't any, we're staying away from confidential information, right?
right, yeah,
Okay.
I mean, this is, none of this is confidential to my
Okay.
knowledge. Well, I better, unless the whole testimony is confidential.
No, they're just certain sections, for example,
Okay.
counterparty name.
Well,
being
I'll try to
confidential.
preface the question so that you have time to look to see if I overstep the bounds of confidentiality, trying to see whether it's here or not. On page 9, I believe it talks about DEC has more megawatts than DEP. Is that correct? Is that what I'm reading here?
Yes, that's correct.
Why is that? I mean, if you're talking about solar energy, DEP certainly has more solar in it than DEC. Why does DEC have more megawatts than DEP?
I'm going to let Ms. Heber address that.
So for CPRE, one of the goals of the program was to try to balance the megawatts brought on solar for the systems. And so the target quantities in each of the tranches of CPRE were skewed more towards DEC than DEP. And so I think the tranche 1 and 2, you had a 78 megawatt project and a 7 megawatt project in DEP, but you had many more megawatts in DEC. Again, that just has to do with the goals of the program for CPRE and what was meant to be done over those years that the program was in place.
Okay, all right. One more question, maybe. Mr. Van Bart, that's all the questions I have. Thank you.
Okay, very good. Ms. Commissioner Cameron? Okay. And before I do anything else, I got to do a couple of things. First of all, I included Lazard's 2025 LCOE report of June 2025 and that DEP Roxborough steam plant application for judicial notice. I want to make sure that there are no objections moving forward. Seeing none. Mr. Ledford? No, okay. Also, were there any summaries, pre-file testimony? And we've done all that, right? Okay, so you're good. No other questions? Are there any questions on commissioners' questions?
None from the public staff.
None from the
Okay,
company.
then we can excuse the witnesses. Thank you very much. Very good. Yeah.
It's our turn, Presiding Commissioner.
Yeah, oh, yeah, sorry.
Vandenvart, I'll
Please,
call.
Mr. Allen, go ahead and
Thank
have
you.
your witnesses.
Public staff calls Syed Imam and Caleb Hill to the stand.
Thank you. And if I could get you to put your left hand on the Bible and raise your right hand. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, and go ahead and
Thank you,
introduce.
Presiding Commissioner Vandenvart. I'll start with you, Mr. Imam. Mr. Imam, would you please state your name, your business address, and your current position for the record?
Sure. My name is Syed Muzammil Imam, and my business address is 430 North Salisbury Street, Raleigh, North Carolina, 27699. My current position is I'm the regulatory analyst in accounting division in electric section for the public staff.
Thank you. And Mr. Imam, on September 2nd, 2025, did you prepare and cause to be filed in this docket an affidavit consisting of 6 pages and 1 appendix?
Yes.
Do you have any changes or correction to your pre-filed affidavit?
No.
And do the contents of that affidavit remain true and accurate to the best of your knowledge?
Yes.
Okay. Mr. Hill, I'll now turn to you. Would you please state your name, your business address, and current position for the record?
Good afternoon, Commissioners. Caleb Hill with the Public Staff Energy Division. My business address is 430 North Salisbury Street, Raleigh, North Carolina.
And your current position?
Oh, I'm an engineer with the Public Staff Energy Division.
And Mr. Hill, on September 2nd, 2025, did you prepare and cause to be filed in this docket an affidavit consisting of 4 pages and 1 appendix?
Yes.
Do you have any changes or corrections to your pre-filed affidavit?
No, I don't.
And do the contents of that affidavit remain true and accurate to the best of your knowledge?
Yes, they do.
Presiding Commissioner Vandenvart, at this time, I would move that the pre-filed affidavit of Syed Imam consisting of 6 pages and 1 appendix, and the pre-filed affidavit of Caleb Hill consisting of 4 pages and 1 appendix be admitted into the record at the appropriate time.
So moved.
And I understand that no parties have cross-examination for Mr. Imam and Mr. Hill, and they're available for
Okay, I thank you very much. I really only have one question, which is, I hope you can answer the question I couldn't get earlier. Could you give me a little bit of explanation of how the avoided cost is calculated relevant to the CPRE? I believe it's tied to a simple cycle combustion turbine, but could you explain beyond that?
Yes, I can try to answer that question. I will say that I'm not the expert at avoided cost, so subject to check on some of these items. But for my understanding is that the avoided capacity is determined through a CT combustion turbine unit, and the avoided costs and explain a little bit more on that. Apologies. The avoided cost for capacity is determined by seeing what the price of that next CT unit would be, and then determining what that would be on a dollar per kilowatt hour basis. For avoided energy, the calculation is a little bit different. For avoided energy, $100 100 megawatts of free energy is provided to the production cost model, and then several runs are done to see what the reduction in overall prices would be with that added free energy. And then the delta between the base case and the new case with the added free energy is how we set the avoided energy cost, and it's calculated on a dollar per megawatt hour basis or dollar per kilowatt hour basis. Apologies.
So, and it's that dollar per kilowatt hour that I have a question about. I mean, wouldn't that be very sensitive to, in the case of a simple cycle, wouldn't that be very sensitive to your assumed yearly capacity factor, I mean, if it were 10% versus 20%, let's say, you would be dividing the costs, spreading it over more megawatt hours. Do you know if a capacity factor is assumed?
Unfortunately, that does go beyond my expertise.
Okay,
on the avoided costs.
All right. That's the only questions I've got. Do we have any questions from the other commissioners? Do we have any other questions on commissioners' questions?
None from the company.
None from the public staff.
Okay, do we need to enter anything? I think you all are excused. Thank you very much.
Thank you.
Do we have any other motions to put things in the record? There's a letter in lieu of rebuttal testimony. Does anybody claim that?
Yeah.
I think it's DEP's rebuttal.
Yes, DEP did file a letter in lieu of rebuttal.
Would you like to enter that into?
And
the
I,
record?
yes, at the time would request that enter into the record if there's no objection.
No objection, so moved. Finally, just out of an abundance of caution, we'd like to, I think during Commissioner Tucker's questioning, he may have said
A counterparty name.
yes.
Which is confidential.
Yes. So we're going to deal with that after this hearing. Okay.
That works.
Any other matters? Okay, hearing none, we're adjourned. Thank you very much.